Kindly. Yes. Roll. Today listed. Tomorrow 2:30. Civil contempt for admission tomorrow. What is that? It's in respect of a cooperative society matter. There was an order by the first respondent, assistant registrar of cooperative societies, that the inspection should be made, and sales officer was appointed as the inspector, and he inspected and he gave a report stating that there is no allegations against the petitioner, complainant society. And in spite of that, he has initiated a parallel proceedings, and I had challenged the said order before this honorable court, before the single judge. And the learned single judge has passed an order of staying all further proceedings, my lord. And even in spite of that, the accused is bent upon to take over the society, my lord. 6th February.
Lord, this contempt petition, this is the second contempt petition, my lord.
Yes. Yes.
Lord, this is the second contempt petition.
Yes, madam. Right.
Which was,
Yes.
my lord, this was disposed of on 27/6/2024, wherein the direction has been given to the AC not to mutate the entire revenue records in the name of the complainant. 6 weeks time has been given. My lord, 6 months has been gone, still he has not complied with the order.
Contempt matter.
Please, my lord.
11th.
This is a labor matter, my lord. This court instructed me before 10 days back, my lord. If it is not listed, we'll take up the memo, my lord.
Not listed.
It is not listed.
What is it?
It's a labor matter, my lord. The appellant is erroneously appeal, my lord.
What is it? 12th February.
He is the only breadwinner of the family.
12th February.
Oh, thank you.
Yes.
Your lordship.
57.
File wakalat, my lord, seal obtain NOC wakalat from the present applicant. Who is on the book?
57. When do you want? 13th February.
Your lordship.
My
it's
lord,
an-
serial number
Kind indulgence.
42. Serial number
My lord.
42, my lords.
42.
Yes, my lords. I appear for the complainant. The accused was supposed to file the counter, which they have. If my lords may kindly grant me a week's time to file the reply, I shall do so, my lords.
42, 18th February.
My lord, 63, my lord.
Kind indulgence. A shorter date, if I may request.
Your lordship's kind in.
35, there's some difficulty and adjournment will be granted.
35.
35, item number 35. I've informed the other side.
When do you want? When do you want?
3 weeks time may be given.
3 weeks time.
My lord,
25th of February.
Much obliged.
serial number.
Your lordship's kind indulgence. Lordship, kind indulgence.
Your lordship, it concerns an appeal by a PSU. It is regarding allocation of petrol pump. The single judge bench has allowed for the petition. So it causes a multiplicity of issue. Therefore, if it may be taken up on an urgent basis.
11th February.
My lord, serial number
Your lordship's
63.
kind indulgence. Sir, 29, Lord.
27.
29.
29.
Lord, this is one. Yesterday, there's some little headache in there. But 2 days time, I have granted to the log this matter.
It is PIL.
Please, lords.
Regarding?
Regarding this, my lord, that one lime company was commenced, and because of this one, Lord, there's little this one. I will argue within 2 hours, 2 to 3 days.
10th February.
10th February, much obliged.
With my lord's kind permission, serial number 56, my lords.
56.
I appear for the accused. The parties are trying to amicably settle the issues. If 2 weeks' time could be granted.
Here for the complaint.
It was
My
stated
lord,
that it was stated that the parties are engaged in the settling the matter.
Very
In
well.
that view, as requested, stand over to 20th February. 20th February, Mr.
Very well, my lords.
20th.
My lord, serial number 63, my lord.
Your lordship, serial number 62. On last
62.
62, your lordship. On last occasion, lordship asked me to appear physically.
We never ask anybody to appear. All are welcome.
However, the notices have been served and the wakalat is filed by the respondents, and the matter may be taken up for hearing.
It is meant for being taken up.
My lord, last occasion it was noted that the notices are not served in the causelets. Yesterday only all the respondents have filed the wakalat. 62, your lordship.
So we'll take up when it reaches
Obliged.
the polar appearance.
My lord, serial number 63, my lord.
63, yes.
Yes, my lord. My lord, this is covered by the recent Supreme Court judgment. In fact, our prayer is in line with the Supreme Court judgment. So a date might be fixed, short date, and this can be disposed of, my lord, the matter. This is in regards to the amendment that is made by the KERC to the condition of supply, where they have made an amendment stating that the electricity connection can be given without the occupancy certificate. But the recent Supreme Court judgment clearly says only on production of occupancy certificate or completion certificate, the connections like water, sewage, and electricity.
Which is the judgment?
We have furnished a memo day first today, my lord. The judgment.
27th at 2:30.
All right, my lord. Obliged, my lord.
My lord, serial number 15, my lord. List 1, serial number 15, my lord. I appear for the respondent, my lord. I have informed the other side, my lord. I pray for
1 second. 63. No, view. Yes, Mr.
My lord, I'm for the respondent in item number 15, my lord. I pray for 4 weeks time.
Item
Item number
number
15.
115.
Yes, my lord.
15, yes.
My lord, I appear for the appellant in that matter. May I request for it to be had on 19th of February, my lord? I appear for the appellant in the matter that the counsel is mentioning. He wants time. I have no objection.
No time. Why we are not going time? Why do you want time? Let us see.
My lord, senior is not keeping well, my lord. That is the reason.
Let us see. Let it be called.
Very good.
So any other mention through VCC?
Your Honor, appearing for a serial number 77
77.
for
Yes.
the petitioners, your lord. Your lord, may I request 1 week of time, as my senior is not in town and he has a medical emergency.
So you're in mobile court?
Yes, your honor, I'm on the way for the court, that's why.
Anyway, which date do you want?
Any date after 2 weeks, your lord.
After 2 weeks. 20th, 27 February.
Much obliged, my lord.
Permissions. So contempt matter, seal number 1. Anusha L.
Notice returnable. 8 February.
Seal number 2. SB total.
Notice returnable. 27th. Please.
Seal number 3. So Muni Raja M.
3 to 5, my lord. Notice returnable. Yes. 28 February.
3 to 5. 4. 5.
Also. All.
Seal number 6. So Praveen Kumar I quoted.
Notice returnable 28.
What will you do? Seal number 7. Mr. Raju, yes.
Notice. Notice returnable on 27th.
Seal number 8.
Connected matter is posted on 4/3, my lord.
4th February, 4th March.
4th March.
Notice returnable 4th March.
Seal number 9. Mr. Padmanabh R.
I appear for complainant, my lord.
Notice returnable. Complied with.
Complainant, my lord. Appear for complainant.
On 28 February. Please.
Seal number 10.
The complainant.
Now
Returnable on.
May I request for the hand delivery also, my lord, in the notice.
Service of summons by hand delivery is permitted in addition to normal mode of service.
Great.
This is PL matter, seal number 11. Seal number 11.
In this case, our affidavit is ready, my lord, to show the best practices insofar as fencing is concerned, my lord. I'll file it in the counter today, my lord. I'll serve a copy on the learned amicus curiae. Lordship may kindly take it up on any other date.
Any other date?
Any other date, my lord. Or
My lord, may I
Kinsman,
make
pass
one
on.
submission?
That Kamala matter?
Kamala matter is next matter, my lord, serial number 12. My lord, serial number 11.2. My lord, though it is an elephant matter, my lord may delink it for the reason, my lord, the elephant is dead. I have filed the statement of objection.
12 is elephant matter.
12 is Kambala, 11.2
11.2.
may be delinked, my lord.
So 11.2 may be listed on which date? 27th of
No, any date, because I filed my statement also.
Is over. Will not survive.
No,
So 11.2, read petition 240624 to be listed on 27th at 2:30.
obliged.
I'll serve the copy on the other side.
So then we'll give some.
Yes.
Both can.
Seal number 12.
My lord, this is the Kambala matter. My lord, the statement is ready. My lord, I'll serve it if my lord could have it on 28th, my lord.
28.
Yes, of January.
I bow
I've
down.
informed the opposite side also.
Copy of the same will be furnished, your lordship.
My lord is there.
He'll be giving. 28 January is what day?
Tuesday, my lord.
Tuesday, all right, Tuesday, 28 January.
My lords, for the petitioner, on the last date, the committee was constituted for the Kambala event.
Yes, my lord.
I have written certain representations. I'm placing that on record, my lords.
File in the register.
I'll file it at the registry.
Obliged, my lord.
28 as requested jointly by all the learned advocates.
This number 13.
My
Senate
lords,
appeal.
just a small request. There's an amendment for the impleading IA which has to be carried out in my lord's set. It's already been carried out in the second set. I've been requested to ask permission if I may take the copy of the set and carry out the amendment.
Number 13.
Yes. Lord, I appear for the appellant. What has happened is, my lord, there was an order passed by this honorable court, where under, my lord, this honorable court, my lord, when I challenged, my lord, the acquisition, they laid down, my lord, 6 parameters and said, my lord, if it is a garden land, it is to be, my lord, deleted from acquisition. Thereafter, my lord, the BD has passed an order saying that this is a forest land and therefore, my lord, this does not, my lord, fall within the ambit of acquisition. My submission to your lordship says, my lord, we challenge that order. That has been dismissed, my lord, we are before your lordships.
There is a second petition.
Because matter will have to be heard.
Connected discipline is one. Connected discipline. List ಆಗಿಲ್ಲ. How? Connected discipline? ಆಗಿದೆ. 1, 2, 9. We'll point out that. Really, close it. We have to decide how we'll give it to. What is that scheme which is lapsed?
Please, my lord.
Some scheme is directed to be lapsed. What is that scheme?
My lord, strictly, my lord,
Not
scheme-
schemes.
not scheme, my lord.
Acquisition.
Here, what has happened is,
There was earlier, my lord, I had challenged the writ petition, my lord, in a writ petition, the accusation itself. Page 236, my lord, if my lords turn to, at my lord 384.
You are claiming ownership.
Yes, I'm the owner, my lord. That's undisputed.
So then you are also saying that it's forest land.
I have not said. The BDA, my lord, thereafter, my lord, said, my lord, when I challenged the acquisition. When I challenged, BDA, my lord, sought to acquire this land. I challenged the acquisition. This honorable court, my lord, specifically directed that if it is forest land, or my lord, if it is, there are built up space, my lord, you can give a representation. BDA will have to exclude it from acquisition. I gave a representation. They, my lord, the SLA, my lord, land acquisition officer went and inspected. He says, my lord, it's full of trees, coconut trees, my lord, areca trees, my lord, whole lot of, my lord, fruit bearing trees, everything. Thereafter, my lord, the BDA says now it's a forest land, and therefore, my lord, rejects my application. My submission to your lordship says they acquire the land. That, my lord, it is full of, my lord, trees, my lord, is undisputed. That I am the owner is not disputed. They, my lord, now simply say that it's a forest land. My submission to your lord, in the meanwhile, my lord, this honorable court, my lord, when it passed the order earlier, specifically said you will not do anything in relation to this, maintain status quo. Now they say part of the land has been, some sites have been formed and given to third parties. My submission is, my lord, there was a status quo order. They have virtually committed contempt if they have done so. In fact, my lord, we had filed contempt petition. There they gave undertaking that, my lord, they will.
Then your assertion about ownership is indirectly outstayed.
My lord, it is not, my lord. I'll tell your lordship why. BDA says it is a forest land. My lord, there must be a notification that it is a forest.
Give a separate fresh new cause of action for you to challenge that this is already challenged of treating the land as forestless.
My lord, that, my lord, we had, my lord, separately, my lord, they initiated forest proceeding.
Pending before the forest officer.
I challenged it. My lord, there is a stay order in my favor. That's why, my lord, on the last occasion, my lord, we have placed all that before your lordships. Matter will have to be heard, that's all. Need it convenient to your lordships, my lord, otherwise, my lord, I'll continue with this.
Today, what is the judgment of learned single judge?
The judge, my lord, has dismissed my petition because I went, my lord, before the learned single judge after the order passed by the BDA saying that it is forest land, therefore your application rejected.
Probably the entire outcome of this controversy or this appeal depend upon the proceedings which you have challenged before the conservator of forest.
My lord, in that event, your lordships will have to postpone it because what happens is, whether, my lord, it is forest or land, ultimately will fall before your, it come before your lordships.
Sir, but that entire area is popularly known as Thurahalli Forest.
Thurahalli Forest.
I mean, from our childhood days, at least we are. We may be wrong legally. I'm not saying that, but that is the general understanding of
according
all the persons.
No, I understand.
According
to us, my lord,
16 of this.
If, my lord, if it is a forest land, then how did the BDA, my lord, allot sites to third parties? I ask myself. Please get it.
Allotted to third party.
Yes. My lord, my learned Mr.
Now, which collateral proceedings are pending before the conservator forest? Your
No, they, my lord, initiated proceedings. My lord, forest department initiated proceedings against me. I challenge that, my lord, there is a stay order.
So that proceeding will decide the fate of this.
In a significant way, my lord, because that question as to whether it is forest land is outstanding. The question as to whether it is forest land, according to them, is outstanding because they say a survey should be conducted to determine the area. Survey, as a matter of fact, has been conducted. And the only land which is left out were a road where, my lord, we've already put up a road. The BDA has already put up a road, identifying it. And after, of course, my lord, taking possession of the property, a road has been put up. And thereafter, a small strip of land is outside the forest area, in which, my lord, sites have been formed. Because possession of the land had been taken over even before this learned single judge's order in the first round of litigation when they challenged the acquisition. Once the matter went back, the government wrote, my lord, to us saying this is forest land and the boundary is here. That is when, my lord, a resolution was passed by the BDA saying this is forest land and therefore we cannot proceed with the acquisition any further. Therefore, in a way, my lord, the land went back to the forest. Out of that, a small strip of land which was left were made into sites and allotted to various parties. Therefore, even if they ultimately succeed, they must succeed in showing that it is not forest land. And learned single judge is right in saying that the land acquisition has been completed, possession has been taken, because they admitted that a road has been found in their land. Once the road has been formed, the question of saying I'm in possession can't
And
arise.
what about the green belt over there? Because that entire area was
Yes.
earlier a green belt. I don't know right now what it is.
Yes, it is the case.
It is the
It
green
is the
belt.
case. As a matter of fact,
If it is
the
green
forest
belt, my
has.
lord, I asked myself, how did they, my lord, form
Correct.
the sites? One. Secondly,
No.
there was an interim order passed by the learned single judge, my lord, way back in the year 2006. Moment, my lord, the acquisition notification was issued. I, my lord, came before this honorable court. An interim order was granted, my lord, restraining them from taking possession from my property, That was continued, my lord, in the final order. My lord, please look at page 385. This honorable court specifically said, till the exercise is undertaken, you will not dispossess them. Then I asked myself, how did they, my lord, form the layout?
Because possession was taken even before the
Where?
interim
How?
order was
Where?
granted.
My lord,
Of course,
if
I've
that
produced
is so,
documents to show that.
please look at, my lord, the order passed. There were parties there.
If not,
In the, before the learned single judge.
a huge batch of cases, my lord, in a huge batch of cases which were filed, an interim order was granted. But even before the interim order had been granted, not only had we taken possession of the property, we had also formed the road, and they admitted it. They wrote a letter to the BDA saying, please grant me the rest of the land other than the land in which road has been formed. There's a specific letter from them admitting to the fact that possession has been taken. Then my lord, to turn around and say, no, possession has not been taken, learned single judge says it can't be said. Because land of which you're making a claim, possession has already been taken.
My lord, if a possession is taken, there must be a master. There must be, my lord, some document. Where is this that they have produced? Nothing, not a scrap of paper.
It's on record.
Let's have a look at it.
We will defer the hearing of this.
My lord, look at, my lord, the master.
My lord, only,
Style.
we'll admit and, no, my lord, only problem is, my lord, we have been allotted with these sites. We are in possession of the property. And more so, my lord, the acquisition amount is already been withdrawn by the appellant here in here. The amount what was deposited by the defendant BDA before the LAC proceedings court has been withdrawn. I've got a copy which says that he has participated in the LAC proceedings, withdrawn the amount. When he has withdrawn the amount, can he again come back before this honorable court and say the notification is wrong?
I have not withdrawn a penny. Let them point out, my lord, that I have withdrawn, my lord.
I have got a copy for which he has withdrawn, participating in the LAC proceedings.
You copy.
You copy.
Give us a copy. You can't, you know, have it in your pocket and
Later on, they say that it's impersonation and impersonation is case pending before the LAC court. Can the writ court go into all those proceedings now? And by virtue of this writ petition and writ appeal, they are coming in way of our enjoying of the property, Your Honor. We have paid our entire money. We are waiting for a site. We are genuine.
You are a third party.
My lord, I am an allottee under the BDA.
They have the allottees.
I don't know, my lord, they have given.
If you have accepted the compensation and without any protest, then.
My lord, please look at, my lord, 1437 of my writ petition, my lord, appeal papers. Somebody else has withdrawn. I have not received a penny. I have, my lord.
How can it be?
My lord, please look at it. There's a complaint lodged by me, my lord, before the registrar of this honorable court. Please have a look at it. 1437. In fact, I am told imposter, my lord, has deposited the back, my lord, the amount also. Please look at, my lord, 1437.
Letter saying someone has committed fraud.
If my learned friend had given this earlier, my lord, we would have filed detailed objections even to this.
Amount of 1 crore 70 lakhs. That was Mr. Holla deposited in your account. As per the order passed by some in earlier petition. 7th August 24. It's also not disputed by the petitioner. Very petitioner. Giriyanna KT. That the said sum was deposited by the first respondent, special land agreement officer, and the amount was deposited into savings account of the petitioner, the ICICI Bank, Kagalipura Brigade Meadows Branch, Bengaluru. Subsequently, it appears that another person with the same name, the petitioner, filed an application on 51, seeking to recall the order. Grounded.
What is this?
We do not, these all are disputed. Yes.
My lord, let me file my objections. I don't know, my lord. I don't even know. But the fact is, my lord, that we had lodged a complaint before this honorable court.
My lord, the present status of land, if your lordship is pleased to appreciate, I filed a memo along with the photographs of the present state with GPS locations on 19/3/2024. Your lordship, please for a moment, if you can have a look at those photographs, which will clearly show how the sites, there is no garden land, there is nothing, sites are formed. We have put our compound walls. We are in possession. For a moment, if your lordship is pleased to appreciate the memo filed by me with the documents, the photographs on 19/3/2024, Your Honor.
I'm for the BDA. I'm for the BD.
This is a problem.
So what is your response to what?
I am under him claiming he is
We have allotted sites to them. No, they have developed also.
No, my lord.
No construction is put up.
Nothing, my lord. We have produced, my lord, the photographs. There is nothing there.
You just
Not
said
even, my lord,
compound
the form.
Layout is formed, compound walls have been put up.
Where?
In those sites. Not by us, but by the authority.
Really speaking, you are not challenging the acquisition. You are challenging the status of the.
My lord, no, my lord. I have challenged, my lord, let me point out this. I had challenged the acquisition. Then, my lord, this honorable court specifically said if your property is a garden land, my lord, it will be deleted. I, my lord, made a representation. The authorities, my lord, went and inspected. Please come to, my lord,
Now your challenge to acquisition will come subsequent to your establishing your title.
Yes.
And getting it.
My lord, my title, my lord, is not disputed at all. Even according to the BDA, my lord, I was shown as the owner and, my lord, they have acquired the land.
Then there's one more interesting development, my lord. Now the petitioner who's before, or the applicant who's before your lordships, has apparently entered into an agreement to sell this property to someone else who has also filed an appeal before your lordships.
Court officer.
Now that other appeal is also before your lordship saying, I am actually entitled to this land. Now that is another complication.
Who has sold?
That is, my lord, the writ appeal.
No.
1297.
An agreement holder under the appellant.
Who has sold?
I'm for the appellant in the.
Who has sold?
The appellant.
Oh.
Not a sale deed, an agreement to sell where he says, I am had to go to his property. Then they come and file another appeal saying, I am now entitled to file an appeal.
My lord, there is no sale deed. I may have entered into an agreement because, my lord, I have to, my lord, if I keep on, my lord, fighting the litigation, I'll have to, my lord, do something.
Your conduct in litigating.
My lord, please look at, my lord,
My lord, that agreement of sale was prior to the preliminary notification.
I just produce the photograph.
Where is
photograph?
Yes, ma'am.
That was never disclosed to the court at any point in time. All of a sudden in the writ appeal, someone else comes and files the writ appeal.
Please.
Which one?
You're filing something,
I'm not filing anything.
Then?
Who's filing? Not me.
That was given earlier. This is the present.
This is a temporary.
1297.
I don't know. Every time you make mistakes.
This is how each site owners are protected their property, Your Honor.
My lord, if it is a BDA property, my lord, I ask myself, how does it say that, my lord, it is a, please look at, my lord, the first photograph itself.
Along with
I'll have to
GPS,
file my objections today.
along with GPS locations, we have just.
Ultimately, you will have to withdraw this.
My lord, let me point out this, my lord.
Irrespective of the outcome of the forest status process.
My submission to your lordship says,
Or it is not maintainable, or whatever. Because of your conduct, because of your acceptance of compensation.
Lord,
And
I have,
because of your selling.
let me, my lord, file my objections to that, my lord, so-called, my lord, order that they have passed. Let me give, my lord, give me an opportunity, I'll file my objections.
In course of
I have
the
not
hearing,
received anything.
in course of the hearing of the appeal, it transpired that
What is this? Who's filing this?
a kind of collateral proceedings before the forest authorities are pending, in which the
Please don't drag me.
duties being considered about the status of the land as to whether the land in question is a forest land or not. It appears that the decision in the said proceedings will have a material bearing on the controversy in this appeal. In that view, the present appeal shall stand deferred to be next posted on 3rd April.
Please.
Maybe earlier, my lord. We are all waiting to enjoy our property which has been allotted, my lord.
But then there is no stay, nothing.
I do agree. My lord, only there's no stay. I do agree.
Except that the litigations are pending.
Yes, my lord. That is where we are not able to, even the plans are not being given to us for the reason that pendency of the writ appeal, Your Honor. They say that we are not put up constructions. We are not able to put up construction. When you approach the authority says there's something hanging on your head.
Please look at, my lord.
We are with folded hands before this honorable court. Even we have fought from 2009.
You are party in that forest.
Yes, my lord. In the forest land, I'm not a party.
They have no interest in that forest land.
In the forest land, we are not a parties at all, Your Honor.
We can't then make any observation in absence of either lawyer not representing anybody or neither nor the forest department is a party.
No, but forest part of it is anyway something which they'll have to succeed in separately, as your lordships correctly pointed out. Only then, Lord, will this question arise of challenging the acquisition.
That is the whole point, Mr.
Because once it is forest, there's no question of
Because you are
making a
holding,
claim.
you are holding this litigation and holding their rights to develop.
No, only thing is, my lord, question is,
Sale deeds are
they
made
themselves,
possession.
my lord, say that this is a garden land. Please look at it. My lord, if it is a forest, there can't be, my lord, fruit-bearing trees, my lord, which I have raised.
Keep it little early.
Very well.
Because
I have no problem. No, I understand. I'm not saying anything.
because the third
No, I
party
understand. I understand.
unnecessarily
Please, my lord.
sandwich between
Please.
the.
Any date, convenient, your lordship.
From 2009, we are waiting for a fruitful at the hands of this honorable court, Your Honor.
11th March.
Please.
My lord,
Keep
in the
your obligation.
connected matter, if I may be submit. There's
All
an office
connect-
objection, my lord.
All connected will go on 11th. Bound to be.
That's the agreement holders.
It's an agreement holders
petition.
appeal here.
Someone else has come.
My lord, there's a compromise decree between the petitioner and myself.
Even worse.
Compromise.
Yes, they have entered into compromise also, Your Honor.
Specific performance, we had filed a suit and it was compromised saying once all of these parallel litigations are done,
Then you get the sale deed executed in your favor. One of the
my lord,
appeal,
pending litigation, I would not be in a position to do.
and then one of your appeal will be over.
But in that
All other-
decree, I had
I
undertaken.
think both appeals now must go, my lord, with this conduct of what they've done behind the back, which is coming to the forefront.
Nothing is brought before any of the courts, Your Honor.
Specific performance. How can it deal with acquired?
Yes, one challenge before the court.
Decrease, yeah.
One way challenging the notification, one way entering before the civil court under a compromise petition.
Would you like to join the authority of the forest?
Well, there's a separate proceeding pending. There's a direction by this honorable court to the
Separate.
forest department
What do you?
to examine it. To examine their objections and to pass a reasoned order. So that proceeding is pending separately.
Lords, our appeal is filed just to support the petition because under the compromise, we were supposed to support them in the litigation to protect this property, man. Our case is not against the petitioner at all. It is in conjunction with the petitioner. Whereas-
What is your appeal?
On the same grounds as the petitioner. They have
They were not a
retained
party. They
possession.
were not a party to the proceedings before the learned single judge. They now file an appeal for the first time.
You can't be permitted to hijack all the senior counsel
And
and by getting your appeal heard. This is lighter way. Because what we mean to say that your appeal has to go with this appeal only. That is all.
my only submission was regards office objections case.
Office objections you may remove. All dispense. All office objections are dispensed with as far as appeal of Miss So and so is concerned. No, don't. Notice. No, we are not issuing.
Still number 14. Lord, I appear for the appellant in 14.1, my lord.
Lords, I appeal
There's
for
an
the-
application for donation of delay.
Lords, I seek some time to file objection to the IA for condonation of delay, my lords. On preliminary objection, my lords, they don't have locus to file the intra-court appeal.
Where is the delay?
In connected matter, my lords.
14.1, my lord.
Lords, I challenge the learned, I challenge the, my lords, entrustment,
Both the appeal arise out of same judge.
same order, my lords.
Then
Yeah.
delay is bound to be condoned.
Lords,
I want to file objection on preliminary objection of locus itself, my lord. So that's why delay may be heard together is what I'm asking.
When you will,
My lords, date, any date, my lord.
15th February.
Oblige, my lords.
Take notice in the matters for pollution control board. The
Respond number 2, my lords. Pollution control board is Gururaj Joshi. Sir.
Pardon?
The pollution control board is responding number 2 in number 14, your lordship. I may be permitted to take notice and a copy may be served so that we can file the next.
No, like notice written. Never.
Notice.
You are waiving.
No, my lords. They are appearing on behalf of respond number 2.
You are for?
My lord, I am for the appellant in
They are
14.
for Lokayukta, my lords.
For the Lokayukta.
They are
my
for
lord.
pollution.
Number is which number?
Serial number 14, my lords.
14.1.
14.
And you are 14.1.
14 pollution control board has.
In
been
14.
And in 14.1 also.
So
the
in
pollution
14, you want notice to be accepted by you.
14.1.
604 of 24, notice returnable on 17th February. Learned advocate Miss. Forget. Forgot. Huh?
Krishika for Mahesh Chaudhary, your lordship.
What's your good name?
Krishika Vaishnav, your lordship.
Rishika Vaidya.
Krishika Vaishnav, your lordship.
Vaishnav, for Mahesh Chaudhary, waives accepts notice on behalf of the State Pollution Control.
I shall serve a copy.
14.1 also, my lord, the pollution control board is made as the respondent number 3, my lord. I'll serve a copy of the appeal. my lord.
Oblige, my lords.
Number 15.
Rohan.
My lord, I appear for the respondent in this, my lord.
Somebody wanted time.
My lord, I prayed for time, my lord.
Why?
My lord, a senior is not keeping well, my lord. That was the.
Nothing in the appeal.
No, no. As a matter of fact, this issue is entirely answered by 2 judgments of the Supreme Court.
What?
The question, Lord, is as to what is the effect of a proceeding before the National Company Law Tribunal, where a company undergoes liquidation. And then, my lord, is taken over under a scheme of arrangement by another entity.
This is about settlement, the Lok Adalat.
Yes, my lord. Settlement.
14 years.
Yes, yes. Settlement in Lok Adalats 14 years back. Then the company which entered into a settlement was subject to corporate insolvency resolution under the IBC code. Then company, my lord, CIRP failed. NCLT directed liquidation of the company. In liquidation, my lord, another entity took over the company under a scheme of arrangement. The scheme of arrangement provided, my lord, that whatever claims are there before the liquidator alone are accepted, everything else stands extinguished. And your lordships know, my lord, under the Companies Act, when a scheme of arrangement is brought about, the effect is nullification of claims which are otherwise not existing. And therefore, the entire claims came to an end. Therefore, a request was made saying these claims were not even made before the official liquidator. And even if it had been made, my lord, it would have been treated in terms of the scheme of arrangement. And therefore, because the original entity vanished and subsequently someone else took over the entity, your lordships know, my lord, and the Supreme Court has now said, under the IBC code, it's a clean slate doctrine. A clean slate doctrine meaning everything comes to an end and you start afresh in the entity. Then, my lord, that was exactly what was pointed out to the court. Court says a judgment where a judgment is passed or a decree is there stands on a different footing, which in my humble submission is contrary to the definition of the word claim in the IBC code. Would your lordship only look at the definition? Lord? That makes the entire answer to this case. And the clean slate doctrine in my humble submission has been completely ignored by the learned single judge. Which, my lord, in Ghanshyam Mishra and several judges, Supreme Court has now said, under the IBC code, when a takeover happens, it is clean slate. Because the person who takes over cannot be subjected to liabilities, which may be there or may not be there. Because the company must thereafter survive. Your lordships know, my lord, so many financial creditors give a huge haircut in the liability.
When shall we keep? They are asking time.
Yes. Any date, lordship.
Yes, Mr. When shall we keep?
My lord, I pray for 3 weeks' time, my lord.
3 weeks' time.
My lord, senior's health condition is not good, my lord. Senior's health condition is not good, my lord. That is the
Health
reason.
condition.
No, let them not precipitate matters till then, my lord. I don't want them to start execution proceedings against us on this basis.
You will not then create some equities or start some proceeding, Mr.
Yes, my lord.
Learned advocate, Mr. Radha Kumar. What is your good name?
My lord, Suhas for MC Ravi Kumar.
appears for the respondent to submit that the learned senior counsel who is to conduct the matter is in indisposed health, therefore 3 weeks' time may be granted. Full stop. So we'll record your statement that you will not initiate the execution.
Not precipitate anything, because
Not full stop. We'll record that.
Yes, ma'am.
Full stop. While learned senior advocate Mr. Dhyan Chinna for the appellant has no objection to the court granting time, he submitted that execution proceedings, if initiated, will create new equities and multiplicity of proceedings. Full stop. At the request of respondent, stand over to 3 weeks you want.
Yes, my lord. Please.
18th February.
Obliged, my lord.
can it be 19th?
It is observed 19th February.
Great.
It is observed that the parties shall not precipitate the subject matter.
Complete.
Any respect.
Yes. Very good.
Number 16, HL Pradeep Kumar.
My lord.
Lord, portion of the order, my lord, is under challenge. A portion of the order, my lord, only insofar as to pay interest, my lord, to the deposit made by my lord, the respond number 1 to my lord, the board, to allot my lord, page number 38, my lord.
Compound interest is rejected.
Page number 39 is important, and my lord, that has been clarified in page number 41. Page 41.
41. What is that?
Lord, the single judge, my lord, directed, my lord, the Industrial Development Board to, my lord, pay interest at the rate of 6%. The last paragraph, my lord, clarification is sought and so on. So the operative portion of the order, as the rate of the interest is not indicated and is ambiguous, I deem it appropriate to order that the petitioner would be entitled for interest at the rate of 6% from the date on which it is deposited till the date of refund to the petitioner. Lord, Lord, as per Annexure D, my lord, page number 82.
You are challenging interest part only.
Only, my lord, rest of the thing, my lord, the amount has been refunded, my lord, during the pendency of the, my lord,
Interest
reputation.
is on what amount?
Lord, they had the deposited, my lord, 6 crores rupees, my lord, out of, my lord, 165 crores to be deposited for allotment of, my lord, the industrial plot. So they did not, my lord, pay entire amount. They paid only 6 crores. So, my lord, the project, my lord, we could not allot the land. So, my lord, the judge, my lord, single judge, my lord, held that, my lord, due to, my lord, actions of the state government and the board, the project could not be implemented. So, my lord, we have to pay interest to the, my lord, that amount, my lord. That during the pendency of that, my lord, writ petition, we have, my lord, refunded, my lord, 6 crores rupees. Page number 82, Annexure, my lord, D. They, my lord.
Where is the original order where interest was not granted? Page 11.
Yes, my lord. Page 11.
30.
Internal page 11, my lord, index page 38.
So here only it is percentage specified in the subsequent order.
My lord, may I respectfully submit? This appeal is totally devoid of merit, totally misleading. We were setting up a power plant. My lord, they misled us. They told us that the allotment is being done out of the land acquired. They kindly, my lord, just allow me, I have come from Delhi. I'll just point out how misleading and what lies they speak before the court. Totally misleading, totally devoid of many merits. My lord, may I trouble this court? Page 9, my lord. Para 9, page 12. My lord,
Para?
my lord,
Para 9.
my lord,
Nine of-
para 9,
Appeal memo,
your
appeal.
page 12,
Your memorandum,
Yes, my lord.
the appeal memorandum.
appeal memo. Para 12. Para 12,
Para 9.
Para 9,
para 9, page 12.
page 12.
Yes.
My lord, they say the committee after detailed deliberations,
No, where is that? One second.
after fifth line, sixth line,
All right. The committee after detailed delivery. Yes.
detailed deliberations had decided for allotment of 330 acres of land out of 1057 acres of land acquired for IIT at Hassan. My lord, this goes on to para 10 also below here. Again, they say in the fourth line, 330 acres of land out of 1057 acres of land acquired. My lord, this is further confirmed in annexure H, page 94. Page 94. Middle of the middle of the page, my lord. Subject number 21, file number 192.
13.
Do my lord have page 94? My lord. Subject number 21 in the middle of the page. File number 19213. My lord, request of Hassan Thermal Power for allotment of this. After detailed discussion, it was resolved that an extent of 330 acres of land out of 103 land acquired for IIT at Hassan be allotted as my lord, this goes at page 96. They sent a formal communication to us, page 96. Here is the letter from KIDB. In this first para, line 3, third line, they say, here is the extent of 330 acres of land out of 1057 acres, 24 guntras of land acquired for IIT. My lord, relying absolutely, we placed our reliance on this. When what we did, we did MOEF clearance. We spent at least 1.5 crore on getting 2 MOEF clearance. Then 40 kilometers from where the water was allocated to us, we laid the line. We carried out surveys. We carried out, went and did everything. My lord, what we finally found, ultimately when the project was cancelled and the learned single judge has found that this was not due to our fault. This was due to the failure of the government that the project was cancelled. This is the finding of the single judge. The learned single judge. This is a finding of the learned single judge that it was the failure of the government that the project failed. It is also the finding of the learned single judge that KIDB made unfair and this is unfair enrichment. My lord, they sat on my money, and when I filed a writ, there was I just want to point out a simple fact before my lords. My lord, when the project was cancelled by the government, I filed a writ petition challenging the cancellation, and KIDB was a respondent. My lord, there was a conciliatory meeting at the instance of the High Court, page 146. My lord, may I trouble my lords, page 146? My lord,
Only interest. Statement may be recorded. Only, my lord, with the interest portion, my lord, this appeal is, my lord. It's fine. My lord, that's not indicated. I'm sorry. Please, my lord. Industrial Areas Development Board. Yes, ma'am.
R.K. Narula. R.K. Narula. Narula. My lord, just 1 minute only. If I've come from Delhi only to say how much they trouble, how much they misled us, how much harm they caused us, how much value we had to suffer in their hands. They did not acquire the land. They misled us. We spent so much of money. My lord, how do I know that they have not acquired? They were just telling me they have acquired. My lord, how do I know that KIDB institution like KIDB will take my money, not acquire the land, mislead us, make us spend money?
You are saying that you are senior enough.
My lord, I know that.
Experience enough to judge your judges.
My lord, yes, my lord, but my lord, someone has to rely on that.
What more we can say?
And
Now listen, heard learner advocate Mr. So-and-so for the.
my lord, and then I don't get the interest also. But I pay higher rate of interest to the banks.
You want to make submission? Please, sir.
Okay.
If you are still want to make submission, you are welcome to make submission. Anything to be submitted on your part?
My lord, I'm only expressing how much I have suffered in their hands.
And learned senior so-and-so for the respondent. This appeal under section 4 of the Karnataka High Court Act 1961 is directed against judgment and order dated 7th June 2024, passed by learned single judge in writ petition number 20598 of 2022, read with
19 July 2020.
order dated 19th July 24, passed in the same proceedings in IA number 1 of 2024, full stop. In the original order dated 7th June 24, learned single judge, while allowing the petition in part, held that the petitioner will be entitled to interest at the bank rate prevailing in the respective years from time to time, from the date of initial deposit till the date it was returned to the petitioner. The claim for compound interest was rejected. It appears that subsequently
Only, my lord, rate is not clarified.
original petitioner filed IA seeking clarification about interest, stating that the rate of interest was not indicated in the original order, full stop. Thereupon, learned single judge clarified the position by order dated 19 July 24, passed in the said interim application to order that the petitioner, then inward comma, the petitioner would be entitled for an interest at 6% per annum from the date on which it deposited the amount, comma, till the date of refund to the petitioner, comma, on the strength of order that is passed on 7th June 2024. The interim application was accordingly disposed of. Paragraph. In course of the hearing of the appeal, learned advocate for the appellant KIADB made a specific statement that the present appeal is confined to, and the appellant confines the same to the order dated 19th July 24, passed in IA number, which was a clarificatory order in IA number 1 of 24, and that no other part of the judgment and order is being challenged, full stop. It could be therefore seen that in the original order dated 7th June 2024, learned single judge had already awarded, or had already held that the petitioner would be entitled to the interest at the bank rate. However, the rate was not specified, full stop. By order dated 19 July 24, aforementioned, comma, it was contemplated that the petitioner would be entitled to interest at the rate of 6% as directed, full stop. In that view, comma, the order under challenge is only clarificatory, full stop, the genesis of which was already found. Genesis was already found in the original order, whereby the interest was awarded and the petitioner was held entitled to interest, full stop. In the aforesaid view, we do not find any merit to, we do not find any reason to entertain the present appeal, full stop. It is to be noted and observed that the principal amount is already refunded to the petitioner, full stop. Furthermore, comma, not furthermore, additionally, comma, the aspect of entitlement of interest for the petitioner was highlighted and analyzed by learned single judge in paragraph 6 of the judgment dated 7th June 2024. It will be relevant to reproduce those observations from paragraph 6, comma, extracting from paragraph 6 of the judgment. The issue now is it will extend to next page.
At least some costs.
Refunded, full stop. For all the aforesaid reasons, the appeal stands meritless. It is dismissed.
So number 17, the G Balakrishna.
Paragraph 16.
This 12th respondents, hairs are before your lordship. 12th respondents, hairs are before your lordship. Learned single judge has allowed the writ petition. At page 43, my lord, is the operative portion of the order of the learned single judge, where the learned single judge has set aside the order of the Tahsildar, my lord, dated 15th March 1990. And the order of the Assistant Commissioner dated 24/5/1994 under the mutation proceedings, my lord. Now, my lord, many things which are unnecessary at this stage, because in the order of the learned single judge says the order is ultimately subject to the decision in a civil suit. OS number 836 of 2000.
Civil suits are pending.
Please. Blood
Pending.
long earlier to the filing of this present suit, this mutation entries 3 decades ago.
During the pendency of the civil suits between the parties, the revenue authorities proceeded to decide the.
No. It is just the contrary, my lord. It is.
But in the background of the decision impugned in the petition, there is a pendency of civil suits.
That's right. Now it is like this, my lord. This 15th March 1990 and 24/5/1994, the order of the Tahsildar and the order of the Assistant Commissioner, where the subject matter of a previous suit, my lord, OS number 554 of 1995, for which both herself and we were the parties. That went, my lord, up to Supreme Court. This OS number 554 of 1995 was dismissed. RA was allowed. It was remanded. In MSA, this honorable court allowed the MSA. And again, dismissed suit. Decision is reported in ILR 2003, Karnataka 3134. They filed appeal to the Supreme Court. Supreme Court dismissed their appeal. That is reported in year 2005, SC 2897, Lord. So ultimately, interested parties, both herself and ourselves, these very orders were the subject matter in that suit. In the plaint itself, they had challenged this orders. Both of us defended these orders of the Tahsildar and the Assistant Commissioner. That is, my lord, this Supreme Court judgment is 28/5/2003. Sale deed is in our favor was in the year 1990. So 24 years later, the present suit came to be filed again, OS number 836 of 2014. Then 2 years after filing this OS number 836 of 2014, revision filed to the government challenging this order of Tahsildar dated 15/3/1990 and 24/5/1994. Sometimes clients want to take a luck, sometimes it clicks. But unfortunately for them, Deputy Commissioner dismissed the revision. He said, you have now filed a suit for declaration of title, sale deed is null and void and all that. You establish your title in the suit, then we will change the record of rights. Then they filed writ petition. In the writ petition, my lord, learned single judge mistakes.
To this court, there is no any declaration suit pending before any court. It is a partition suit, my lord. I am not executing any sale deed.
In the partition suit, he says the sale deeds are null and void 1990. My lord, I will complete my submissions.
Please.
I will complete my submissions. The order of the learned single judge is, learned single judge thinks Assistant Commissioner and Tahsildar have interfered after filing this suit. That is a mistake which the learned single judge commits in the impugned order. Lord, in the at page, Lord, the order of the single judge is at page 41, para 8, where my lord learned single judge just my lord commits mistake. Para 8, having taken note of the findings recorded by the respondents 2 and 3 in revenue proceedings, and the claim made the petitioners being a legal representative of late Municipal, I am of the view that the revenue authorities ought to have relegated the parties to establish their right before the competent civil court. 1990 and 2014 order was the order. However, both the respondent, that is Deputy Commissioner and Assistant Commissioner.
Who is this N. Venkatachalaya?
That Venkatachalaya, my lord, was the
Third.
Original
person who had sold the property to Municipal and all that. My lord. Now what happened is, in that proceeding, both of us were opposing Municipal. He challenged this sale deeds and the mutation entries, the order of the Tahsildar. Under the order of the Tahsildar and Assistant Commissioner, sale deeds were, as per the sale deeds entries were made. He challenged it by filing suit. We were defending it, both of us. This order of Assistant Commissioner and Tahsildar was correct. Ultimately, it went up to Supreme Court upheld. Supreme Court order is 2003. Then 20 years later, 24 years later, they filed the suit, OS number 836 of 2014. We filed application for rejection of plaint. It was rejected. They filed RFA. RFA, it was allowed and remanded to redecide same order 7 rule 11 application. So at this stage, learned single judge said, so there is a civil suit pending. The revenue authorities ought not to have interfered while the suit is pending. Whereas revenue authorities have only dismissed the revision filed by the present plaintiff first respondent, because when suit is filed, they have to establish their title in the suit. Even before suit is decided, they can't say you change the orders or the record of right entries. Now what happened is, the order of the learned single judge's remand is only on the basis that this RFA 1668 of Millard was allowed and remanded. Now we went in appeal to the Supreme Court. Supreme Court has allowed our appeal and has dismissed the suit. So by virtue of the order of the Supreme Court now, Millard, nothing remains, and the order of the Tahsildar and Assistant has to be consequently restored. The order of the learned single judge requires to be set aside. Millard, the order of the Supreme Court, I am producing along with the memo, Millard. It said it is an access of the proceedings.
On this order, my lord, Supreme Court order, the revision petitions are pending before the court, my lord. I have already filed 2 revision petitions are pending, my lord. That is, computer copies are here, my lord. Revision petition number 1692 of 2025 and 1673 of 2025.
Reading para 8, my lord, we understand the learned single judge.
Who are all claiming through Munishamappa?
Lord, I also claim through Munishamappa. What happened? It is like this. Lord, Munishamappa died and his respondents are his heirs. Now, the name of the respondents came to be entered and they executed sale deed in the year 1990 in my favor. That order of the Tahsildar was assailed before the Assistant Commissioner. I also assailed, saying that I have in the meanwhile purchased. So entry should be made in my name. The Assistant Commissioner dismissed the appeals filed by the heirs of Munishamappa and ordered that our name should be, we being purchasers, our name should be entered in the record of rights. That was, my lord, in the year 1994.
First, it was owned by Venkatachala.
Firstly, it was owned by Venkatachalaya.
Yeah.
That property was sold, my lord, it was purchased in,
He sold it to Munishamappa.
in a court auction, Munishamappa purchased it.
From Venkatachalaya, Munishamappa got the
Correct,
property.
correct.
Now the dispute starts from Munishamappa.
No. Disputes, my lord, now intricacy between ourselves. It is like this. Then, my lord, this Venkatachalaya was opposing us. He
Now
fi-
Venkatachalaya does not have a right. His legal heirs are not before the court.
Yes, yes, yes.
It's persons claiming through Munishamappa are having a dispute amongst themselves.
Dispute among themselves. Dispute among themselves.
Some of the legal heirs of Munishamappa sold it in your favor.
Year 1990, my lord, major members have sold, and some of them are consenting members to the sale deed. So, my lord, then they supported this sale deed, filed applications before the civil court's written statement acknowledging, my lord, the sale deeds and the mutations in the civil suit OS number 554 of 1995. Then, my lord, that was filed by, my lord, Venkatachalaya, challenge.
Crosstalk.
Consenting parties.
Let him complete his arguments. We will hear you.
Please, my lord. These very mutation entries were the subject matter, my lord, in the previous suit OS number 554 of 1995. In the plaint averments, my lord, I will read if necessary, my lord, the plaint averments. In the plaint itself, it is stated, Tahsildar has passed an order on 15/3/1990. It is illegal. Tahsildar has passed, Assistant Commissioner has passed an order.
Today, nothing is pending in the civil court.
No, nothing is pending, my lord.
Nothing is pending.
Nothing is pending.
It is pending, my lord. Partition suit is pending because the see
That
the
partition suit is
operative
dismissed by the
portion of
Supreme Court now.
Operative portion
It
of
was
the
dismissed by the
litigation,
Supreme Court now.
There is no reference in the order.
Lord,
No.
may I kindly see the operative portion of the
It is a
petition,
judgment,
my
my lord. I
lord,
will,
page number 44, my lord.
let us
In their volume number 1, in their documents, 44, my lord. 44, my lord.
307.
Please, please, my lord. It is made clear that the third operative portion of it is made clear that till the adjudication of the original suit 307 of 2022 by the competent civil court, parties shall maintain status quo in respect of revenue entries relating to land in question.
This is partition suit.
Please, my lord.
307 is
Please, my lord.
partition.
It is pending.
Between family members of Munishamappa.
Please, my lord. And moreover, my lord, may I kindly see these documents, my lord. I produced now, my lord. It is very clear documents. It is a forged and created documents by the father of the appellant because the criminal case was registered and charge sheet was filed. During the pendency of the criminal case, my lord, he was dead. Then his son is the appellant herein is came before this court and filed this writ appeal. May I kindly see this document, my lord. In the writ petition itself, it clearly shows that as per the Tahsildar endorsed and give statement before this honorable court. Please, sir. Let's. Here is the original documents here. It's all.
Internal.
Copies here.
This is in relation to original suit 554, order 7, rule 11.
Correct, correct. In the present suit, I filed application to reject the plaint.
It was.
Because they are
set
aware of the
aside in
cause of
the
action in
RFA.
the year 50.
307 is still pending.
No, 307 is dismissed now.
Where is that?
This suit itself is
No,
that,
no,
not this
no, no.
836.
On that order.
836
we are
of
challenging before this
2014.
honorable court under the RFA 1628 or 1698 of 2016, where it was set aside the orders of the honorable trial court. Then they proceed the case, my lord, as per the directions of the honorable high court. Same is pending.
This 836 of
Partition suit
2014
is
was
pending till adjudication, my lord.
836 of 2014 was transferred to Hoskote. It was renumbered as OS number 307 of 2022. That's all.
This document, may kindly see this document, my lord, very clearly.
I have produced the order sheet of the court now, rejecting the suit
Documents by the appellant father, my lord.
at page 23, along with the memo. 9/1/2025. The 12 LRs filed memo along with certified copy of the order of the Honorable Apex Court in civil appeal number so and so. Wherein the Honorable Apex Court confirmed the orders passed by this court on IA number 7 rule 11 CP. In view of the orders of the court, suit is disposed of. There is the suit, my lord, OS number 307 of 2022. That is after having been transferred to civil judge Hoskote, my lord. It was here in Bangalore Rural, OS 836 of 2014. After remand, it was transferred to civil judge Hoskote.
What is 836?
Yes, 836, it is now the transferred the case from the newly set up in the Wascot.
It is original 307. Original suit number 307.
No, 307 transferred in the Wascot.
836 old number.
Old number is 337. New number is 836, my lord.
Wait,
Please.
New number is 307. New number 307.
You file the synopsis, dates and events.
Oh.
So that these are not clear because probably 307 is still pending.
No, my lord. That is the order sheet which I have produced before your lordship's order of the trial court in OS number 307 of 2022. This OS 836 of 2014 was transferred to Hoskote. That is referred by the order of the London single judge in the impugned order itself.
Okay, you file synopsis with dates and events. See, the land was initially owned by Venkatachalaya.
Correct, correct.
Now, their legal aids claim it is all closed. They are not before this court. You say on such and such a day, the property was sold in favor of Munishamappa. Then thereafter, give the family tree of Munishamappa and say who sold it in favor of the present purchasers.
Right, right.
And then which legal heir disputed the sale.
Right.
And what has happened to that particular dispute.
Right.
If you file the synopsis, it is easier for us to grasp the facts.
Right, right.
Because both of you are cross-talking and we don't know what the facts are.
It has went so many times, not that that is why confusion comes. Not difficult.
It is very clear that what they are challenging, what they are claiming under the mutation numbers, it is a forged and created documents. There is a before the trial court, before the single judge, Milan.
Then they should have said so in 1995, not to support that mutation.
That, Milan, it is evident document.
We have to adjourn the matter only because both of you are arguing simultaneously.
This is, Milan. It is a created document. They are claiming under the created and forged documents. He himself, the Tahsildar himself came before the court.
Also file your synopsis.
Please, Milan. or rather, they are suppressing the real true
When
facts,
shall-
my lord,
when shall we
and
keep-
mislead to the court.
19th February or little earlier, whenever you.
No, no, your 19th February, your lordship.
19th.
19th February, my lord, sir, I am in
Supreme-
cage of one
Any other
case
date,
is
I
there,
have no
my lord.
objection.
You are
The
before
direction
Supreme Court?
matter.
On 19th February, you are before Supreme Court.
No, 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 in the trial court, my lord. Please, my lord.
So when do you want?
Next date of hearing after 25th,
25th of?
after 25th, any
After
day.
25th February.
Please, any day.
Oh. You are coming from outside.
Because I have one case in before the trial court, my lord.
Trial court.
Trial court
Very good.
is a direction. my lord.
4th March.
Fourth match, please.
Number 18. HR Renuka.
Apple.
ನಮ್ಮ ಲೀಗಲ್ ಗೊತ್ತಿಲ್ಲ ಪರವಾಗಿದೆ your colleague has received it and I have filed the acknowledgement also. ಫೋನ್ ಮಾಡಿದ್ರಲ್ಲ ಬಂದು ಇಸ್ಕೊಂಡು ಹೋದ್ರು ನೋಡಿ ಅಲ್ಲಿ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೇನೆ ಆಫೀಸ್ ರಿಜೆಕ್ಷನ್ ಇಸ್ ರಿಮೂವ್ಡ್. The issue, my lord, is with regard to the unauthorized absence of the respondent, my lord. The case of the corporation, my lord, is that he remained absent for a period of, my lord, for a period from 26/1/2012 to 24/4/2013. That is for a period of 1 year, 3 months. My lord, that has been, my lord, construed as 4 months by the labor court, my lord. In fact, he submitted his duty report itself on 24/4/2013, my lord. And to show that this is the 11th time, my lord, he has remained absent. And second dismissal order, my lord, an earlier occasion also he was dismissed from service. And in the present case, my lord, he produces 9 documents. Only if your lordship could see, my lord, para 10 of my writ appeal, my lord, I have given the dates with the exhibits, my lord. None of the exhibits pertain to the period of absence. Exhibit W1 to W9. This is accepted by the labor court, my lord, as the explanation for the absence. Not a single document except exhibit W9, my lord. It's a report, hematology report, which does not even support the case of the workman, my lord. Now there is a direction to reinstate with continuity of
What
service.
was the total period of absence?
My lord, period
Total-
of absence is 1 year, 3 months.
1 year, 3 months.
Lord, it is not a case.
And this is the second dismissal, my lord. Earlier, he was dismissed from service and he was reinstated, my lord. And totally 11 cases of absence, my lord. The labor court, my lord, in paragraph number 11, notes this, has noted this fact, my lord, that he has remained absent on 11 occasions. In fact, my lord, only one, my lord, if your lordship could see page 61, my lord, in page 61, my lord, only one line, my lord, which I've extracted in my synopsis, my lord, at page 61. Third line, my lord, may I read, my lord?
Page?
Only one line, my lord, page 61. I'm reading from the Labor Court Award. Page 61, third line, my lord. In view of the fact of workmen staying away from work, being admitted, absolutely there is no document to show that the workman had produced documents exhibit W1 to W9 before the corporation on an earlier occasion. It appears he then, my lord, and these are the documents which he produces for the first time before the labor court. The disciplinary authority had no occasion to see these documents, exhibit W1 to W9. Secondly, my lord, at page number 63, the labor court also takes a note that he has remained on 11 occasions, absent on 11 occasions. That is at page 63, my lord, fourth line, my lord.
Lord, I will file.
The fact that the workman was imposed fine on 11 previous occasions of the remaining absent unauthorisedly is not in dispute.
Lord, this is not the case of Lord, the appellant before this learned single judge. Lord, first time they have taken this contention, Lords. Lords, I will file statement to Lords to appeal. Lords, kindly grant me, Lords, at least weeks accommodation, Lords. I will file statement, Lords. Thereafter, let it be considered, Lords. Lords, he has been dismissed from service in 2014.
I'm not reinstated in 2022, my lords. After a long gap of 9 years, he has been reinstated by virtue of this order of this court. Lords, at this stage, my lords, unsettling the, my lords, the issues which is settled. Lords, is highly illegal, my lords. And they are saying all this before this court, my lords. They have not said anything before the single judge, my lord. I will file detailed objections to the appeal, my lords. Let it be considered, my lords. The IA, my lords, for delay may be condoned. Lords, the appeal may be posted for admission, my lords.
My lord, if I'm permitted, my lord, I have one more submission. On 11/6/2014, my lord, he submitted an application before the corporation seeking, my lord, voluntary retirement, my lord, on health grounds. My lord, the corporation agreed, my lord, for the said, and which means, my lord, that he would be given, my lord, all the terminal benefits till the date of acceptance of the voluntary retirement. He wanted back wages, my lord, for the period for which he did not work. For the period for which, my lord, the labor court has not granted.
Lords, I need not 17B, lords, wages, lord. That lords, I remain, lords, the order of the labor court was not complied with. They challenged the order of the labor court before this court by filing a writ petition. Lords, I filed 17B application, lord. The 17B application, lord, the application came to be allowed. Lord, they are bound to give, lord, the wages, lords, under 17B. That they have not given, lord. Lords, my request is, lords, kindly grant me a week's accommodation, lords. I'll file objection. Lords,
Hard learned advocate, so and so for the appellant. Divisional Controller, Bangalore Motor Transport Corporation, and learned advocate, Mr. So and so for the respondent, the original petitioner. At the instance of original petitioner, as the appellant hearing, the challenge in this appeal under section 4 of the Karnataka High Court Act 1961 is addressed to judgment and order dated 8th April 24 of law on a single judge, whereby law on a single judge, while dismissing the writ petition of the appellant hearing, confirms the judgment and order of labor court. Full stop. On the ground that paragraph, the respondent workman had remained unauthorizedly absent between the period from 26/1/12 to 22/5/12, a disciplinary proceeding was initiated against him, which resulted into order of penalty of dismissal passed by the employer corporation. The same was challenged before the labor court by the workman. The labor court Where is the order of labor court?
Well, page 66, my lord, operative portion.
Allowed the reference of the workman in part, set aside the order of dismissal and directed reinstatement of the workman, however, without any back wages. Full stop. When the said order of labor court came to be challenged in the writ petition, on a single judge considered the facts and the evidence before the labor court to observe that the workman had submitted a leave application at exhibit M-2, and that he had also given a representation of the petition to the employer seeking voluntary retirement, which was at exhibit W3. Full stop. It was recorded that the case of the workman was that he had sought leave for remaining absent in view that he was suffering from a disease. Full stop. The medical board examined the workman and gave report indicating that the workman had been suffering from chronic low back ache with non-specific bilateral leg pain as such, and that as such he was unfit to perform this duty of a driver. Learned single judge took note of the said facts, including the application for leave of the petitioner and the report of the medical board indicating the ailment, to come to conclusion that it was due to medical circumstances and medical emergency which prevailed upon the workman to remain, which prevented the workman from coming on duty. Learned single judge recorded the finding on the basis of the operative facts that, which inward comma, the material on record would indicate that the absence on part of the workman cannot be termed as willful absenteeism for the corporation to issue an order of dismissal. You quote this. Learned single judge recorded the finding as under page 22. Accordingly, full stop. The above finding of learned single judge and the consequential dismissal of the petition could hardly be said to be unreasonable. The judgment and order is eminently just, proper and legal, requiring no interference in the appellate jurisdiction. Paragraph about the case of the workman that he was unable to discharge the duty as driver, comma, the learned single judge has proceeded to observe that it would be open for the workman to make a representation in this regard to the corporation seeking the assignment of light work on the basis of the medical report. Full stop. In this observation also, this court is not inclined to interfere with paragraph. The challenge to the judgment and order on a single judge is meritless. The appeal is dismissed.
You have filed contempt lots.
Contempt petition and so on.
My lord, the petition is dismissed, my lord. Because in fact, on the last occasion, my lord,
Lots
your
may
lordship,
submit this lots. Lots, let them lots consider lots in view of the order of this court, lots now in the appeal. But let them consider lots, my continuity of service they have to give lots. It's continuity of service, lots kindly to the order of the learned single judge lots. Learned single judge said the order.
You have filed appeal? Contempt.
Contempt, lots contempt for not complying the order of the learned single judge.
Now they'll comply with.
Let them comply.
In view of the dismissal of the appeal, the contempt petition will not survive. However, it is observed that the compliance of the order of learned single judge will be effected within 6 weeks. Within 4 weeks from the date of service of certified copy of this order.
Of late.
Still number 19.
But I hear for the.
Very much.
What is the matter?
My lord, what had happened was, during the COVID period, my lord, there was that lockdown. Secretary to the central government wrote a letter to the state government saying that, my lord, during this period, they must, my lord, pay wages, contrary to the Payment of Wages Act. That was challenged before, my lord, the Honorable Supreme Court. Please come to, my lord, page 130. So Honorable Supreme Court stayed that order.
So this arises out of some labor court proceeding? No.
My lord, no, my lord. What had happened was, thereafter, my lord, the Honorable Supreme Court dismissed it, saying that leaving open the question. So we filed a writ, my lord. Then there was a reference, my lord, by the from the labor, from the employees.
Let us see Supreme Court order.
Please, my lord.
Which page you are referring to?
My lord, the order of the Supreme Court, my lords, get that at running page. With the memo, we have filed it, my lord. On the last occasion.
The memo you filed.
Akilva. Sorry. Lord, my apologies, my lord.
So it was claimed for some wages.
My lord, the back wages, my lord, I mean, wages during the lockdown period when they did not work. Reference, my lord, by the labor, my lord, by the state is only, my lord, with regard to the question as to whether they are entitled to wages or not. Not with regard to the validity of, my lord, the notification. That, my lord, we had challenged in the writ petition. in furtherance of the orders on of the Supreme Court, my lord, granting us liberty, my lord, to take further, the appropriate action. My lord, please look at, my lord, page 2 of the order of the Supreme Court. After hearing the counsel for the parties, at present, we are not inclined to entertain the writ petitions filed under Article 32. Writ petitions are dismissed. However, all contents are left open to the parties, including the interveners, to be raised in the appropriate forum. That would be, my lord, before this honorable court, because we are challenging the validity and the virus of the notification. If your lordships now look at, my lord, the reference, please come to, my lord, the reference, my lord, order at page 129. 129. This is not, my lord, the issue. At 131, whether it is lawful, my lord, issues, this is what is referred. Whether it is lawful for the laborers representing the garment union, so on, so appeal to pay full, to pay the full pay for lockdown period, so on, so. If yes, laborers represented by government labor union at Laggare, so are eligible for which relief? The issue as to whether the notification, my lord, is valid or not, it has to be decided only by the writ court.
Now, this lockdown was a lockdown under the industrial law or that lockdown?
No, my lord, that is
COVID law.
COVID law, not under the industrial act. Therefore, my lord, the issue as to whether that notification could have been valid or not, my lord, whether it's a constitutional issue which your lordships will have to decide. That's all, my lord. That's a short question.
Now, what learned single judge say?
Learned single judge holds that, my lord, he dismisses the petition saying that, please come to, my lord, running page. That issue does not arise is what he has held. Para 9, my lord, if your lordship sees, my lord. 55, Allah. Sorry. Yes, my lord. Page 55, para 9. As regards the question of constitutional validity is concerned, in view of the fact that the aforesaid communications order have already been withdrawn with effect from 18.5, requirement of considering the constitutional validity would not arise. My lord, if the notification goes, then the labor, my lord, will not have any right to get any back wages. It is only based on the notification that, my lord, they are entitled.
This notification by the
Central government, my lord, central secretary issued that notification. My lords get that at, my lord, page 9.
Ministry of Labor and Employment.
No, Ministry of
93,
Home
my lord.
Affairs.
What does it say?
It says that, my lord, during the lockdown period, you will have to pay them wages.
For 50 days, my lord, this issue came up before the Honorable Supreme Court, my lords. Submission was made, and the Supreme Court, after the COVID receded, they passed an order at page number 169, my lords. Kindly.
Notification is withdrawn.
It was in force for 50 days.
169.
69. One second, sorry.
That is
Operating
not the
post
one,
of
my lord. What I have given your lordships, my lord, is in the memo.
163.
It's the interim order.
My writ petition minutes, they have. 163, paragraph 35 may be seen minutes. 35. During the relevant point of time, the Honorable Supreme Court to consider the whole issue and pass certain directions, minutes. So these directions will start from page now, paragraph 35 onwards. May I read your lordships? In most of the industries, or if your lordships got it at page.
So what is there to challenge? It is only everything is kept open.
That's it.
My lord, if I do not challenge it, my lord, the labor court does not, my lord, have the power to, my lord, look into that aspect, validity of that. Please look at it, my lord. What is the reference made? Please look at, my lord, the reference order, at, my lord, page 129. The validity of this notification is not an issue there at all. It can't be decided by that labor court, my lord. It has to be decided only by your constitutional court, by your lordships.
129.
129, my lord. At 131, if your lordship sees, reference is only with regard to these two by the state government. Whether it is lawful that laborers represented by the garment union, number 8, Laggare Main Road, MIE Colony, Penia, appeal to pay the full pay for lockdown period from so-and-so to so-and-so by the management board of Messrs. Shahi Export, number so-and-so, to the laborers in annexure. If yes, labor represented by the garment union, Laggare, are eligible for which relief? The issue as to the, my lord, whether, my lord, the a notification could have been issued by the central government or not is not an issue, my lord, which could be decided by the labor court. It has to be decided by the writ court by your lordships. And that is why, my lord, the Honorable Supreme Court finally said all contentions left open to be raised before the appropriate forum. That will be, my lord, before your lordships. Reference court, my lord, the labor court can't go into this question with regard to the validity of that notification, which only the Constitutional Court, my lord, under Article 226 can examine. That's the short question. In fact, my lord, the Honorable Supreme Court had initially granted an interim order. Finally, my lord, they said, my lord, we keep open to be raised before the appropriate forum. In fact, my lord, this Honorable Court initially granted an interim order.
If we can say that the labor court is entitled to proceed irrespective of the pendency of notification.
That's it.
Then, my lord, my lord, without ignoring the notification, my lord.
We are saying that. No,
If they say, my lord, I have no problem.
Because, see, Mr. Holla, if you succeed in this appeal and get set aside the notification,
In fact, my lord,
then you will automatically succeed in the labor court.
this Honorable Court has already
If you lose
granted-
here, you will automatically lose there. So we don't want to interject the proceedings of the labor court which are pending to be decided on, probably on evidence.
Because under the Payment of Wages Act, if the workers don't work, my lord, they are not entitled. Whether, my lord, the central government secretary can, my lord, issue this kind of a. Your lordships have already granted an interim order, my lord, in another matter.
You are challenging the virus or
Virus, my lord.
virus itself?
Naturally, my lord. Because they have no power. Under, my lord, law,
Who has-
secretary has issued, my lord, central government secretary.
The disaster management, learned Attorney General for India has submitted submissions before the learned Supreme Court when the matters were raised.
So
my
even
lords.
even if we set aside the notification,
No.
even in then that eventually they have right to approach.
That's all right, my lord.
Yes,
I have
yes,
no problem.
yes.
Absolutely. Therefore, my lord, if your lordships say, hold, that, my lord, they will consider it, my lord, dehorse this notification, I have no problem.
My lord. So we can, hypothetically speaking, we allow this appeal. Set aside the notification. Even then we can say that labor court.
Very well. Please, my
No,
lord.
as-
Please.
My
I
lord,
have no problem.
I'm for the workers, my
So
lord.
that under which provision the secretary has also notified. Come on.
That notification has been withdrawn, my lord. I've not been served with papers, but the learned single
I'll
judge.
give you a copy, my lord. I'm
No,
sorry.
Yes, my lord. I'm for the workers, my lord. I've not been served.
This has
but-
not been issued, I believe, my lord. I'll give a copy, my lord. I'll give him a copy. Because
No, he is saying that notification is withdrawn.
Withdrawn.
No, it's only
a-
for 50 days.
It's
From
only
March
for 50
20th.
days.
It
It's
is-
there in the order, my lord. Single
24.
judge's order.
This
is
has been
there,
recorded by even Honorable
that
Supreme
it has
Court.
been withdrawn.
Only for 50 days.
50 days.
50 days.
Initial lockdown period which was announced, my lords, that is the only period which is in dispute. We have withdrawn after that. The
And that's
notification-
why the
that's been
Supreme
recorded
Court,
by the Honorable Supreme
that's
Court
why
also.
the Supreme Court itself dismissed the matter, my lord, which was challenged there and told you can work out your remedies under the ID Act or whatever it is by initiating conciliation. So we initiated conciliation and in the process of conciliation, it was referred to the court for adjudication.
Then paragraph
50 days is the issue.
Our rights are not from the notification, my lord. I am still in service.
then, my lord, the notification may be quashed. Your lordship, my lord,
There is
direct the
nothing
labor
to
court.
quash, my lord. That notification itself is
Sir.
not there. That's what the Supreme Court has said, my lord, in its order itself.
Lords,
There is no,
But then you are demanding the salary for 50 to 54 days at least.
yes, that is the only question before the court. Now, see, my lord, I have not been terminated. Only during the COVID period, I have not been given, I could not work anywhere else. So the question is, the labor court has to decide whether I have a right at all for those wages, which is
On
pending
facts.
for adjudication. They can raise all the issues before the labor court and say, we don't have a right, then I fail. If I'm able to show to the court under the Payment of Wages Act, I'm entitled to it, only then I can succeed.
Their entire claim is based upon, my lord, the notification. Please come to page 114, 114, para 22. 114, para 22. Claim is based on the notification itself, nothing else. 114, my lord, para 22. As has been made clear, in the order of the Ministry of Labour and Employment dated 23/2020, Ministry of Home Affairs, full wages are to be paid to the worker, even in respect of their absence. First party workmen were ready to work, but they were refused work. I did not refuse work. Therefore, my lord, their entire claim is based upon the notification.
No, my lord.
This page 114 is what?
This is, my lord, the reference, my lord. They made an application before the deputy commissioner, labor commissioner, for reference to the labor code.
My
It
lord,
is, my lord, therefore, my lord, their entire claim is based upon the notification.
no, my lord.
Total period, they want, not 54 days.
That my lord, 54
So
days.
the dispute boils down to the entitlement for 50 to 54 days.
Correct.
54 days.
That's the notification, based on only on the notification.
Whether I'm
nothing else.
entitled to under the law of the land, once that the notification has been withdrawn, my lord.
So instead of saying that notification is withdrawn, we can better say that notification is confined to the period of 54 days. That's
54.
Even then, my lord.
that is under challenge.
Yes. So
And your lordships have already granted
But
an interim order.
in respect of
companion
that, the
petition.
Supreme Court has already passed an order, my lord.
Now you show that under which provision, under which authority and power the secretary has issued the notice.
Yes, my
Even
lord.
for 54 days.
That the Supreme Court has already passed an order dismissing the writ petition after considering all that aspect. That order is available.
That's what I told you, lordships. My lord. They've kept open all contentions to be
That-
raised before the appropriate forum.
That the
Page
final,
2.
So all questions are, you show that under which power this notification is issued.
Kindly, may I request you, last, turn to page number 158. Submissions made before the Supreme.
This, where is that notification?
My lord, please come to my lord, running page
Get the copy.
93. This is the first notification.
29th March.
Yes, my lord.
It
20th
refer-
of March, 2020.
It refers to some disaster.
Yes, disaster management provisions of.
Then the second one is, my lord, at page 94.
So in disaster management, you are entitled to.
Objection.
Strictly no, my lord.
No, it is.
Is it
That's why, my lord, your lordships have already granted an interim order, page, what page?
Now you
Page
show,
5.
this is all in a.
Particular period in disaster situation, that's what we made, submissions was made in the same.
So
line.
under which power it is?
Yeah, kindly look at the page number 156, my lords.
150.
56 of the appeal memorandum.
Yes.
The submissions made by the learned Attorney General for India before the Honorable Supreme Court when the very same issue was raised. I may read, my lords.
Oh. Where is that?
Paragraph from 20, my lords. This was
Power to
found,
issue the order dated 29/3/20.
yes, sir.
Certainly-
Certainly be traced to inter-alia.
Under
Section
section 10 of what?
and nothing under section 10 to restrict the ambit of or scope of section 10(1).
Disaster management.
Management Act 2000. The direction dated 29/3/2020 was issued in public interest by the competent authority. The directions are neither arbitrary nor capricious. The ground of financial hardship, incapacity which has been pleaded by the petition is legally untenable ground to challenge the direction issued by the competent authority.
This is a
In
contention.
exercise of statutory power. The Union of India issued the above direction as a temporary measure to mitigate the financial hardship of the employees and workers, especially contractual and casual workers during the lockdown period. The measure was provocatively taken by the respondent to prevent perpetration of financial crisis within the lower strata of the society, laborers and employees. Directions issued by the Government of India where an economic and welfare measures as a benevolence in the objects are to be achieved. She so further submits that by order dated 17/5/2000, the National Executive Committee has revoked its earlier impugned directions with effect from 18th May 2020. Hence, the order remain in operation only for 54 days. The impugned notifications have been outlived their lives. The adjudication of the same would only entail an academic exercise. Learned Council appoints interveners have supported orders issued by the Government of India dated 29/3/20 and other orders and consequential directions. It is submitted that orders dated 20th March 2020 and 29/3/2020 were issued in larger public interest to prevent the possible spread of the disease. It is submitted that when the statutory authority had declared a lockdown, it is also liable to provide for the consequence of the lockdown. In the event the order dated 29th March 2020 struck down, the very lockdown order will be arbitrary and it is also liable to be struck down. The Government of India has offered economic stimulus package to all small and medium industries to enable them to cope with the current financial situation so as to ensure that they can cope with the burden of payment of wages and continue to be viable. The Disaster Management Act 2005 is a self-contained code and no reliance can be placed on any other law. Further, by virtue of Section 72 of the Disaster Management 2005, all other enactments are overridden.
it is further submitted that order impugned seeks to reinforce the pre-existing right of the worker to get their wages without any reduction. The Payment of Wages Act of 19 has also been referred to in support of their submission. And thereafter, my lords, the Honorable Supreme Court at page number 165, 66 minutes. 65. Certain measures, directions were issued, keeping in view all these facts and circumstances of the case and extraordinary situation created due to pandemic.
Section 10 doesn't provide for it, my lord. There can't be any section 10 of the act, if your lordship sees, doesn't provide for anything. No direction to private parties is permissible at all.
But are you facing a huge financial liability?
Yes, my lord. Nearly about 80 crores.
8 crores.
80.
What is the economic stimulus package?
Some provident fund as well as PSI, some interest
No,
subventions, certain things.
you will have to show how they can, their loss can be mitigated.
I take instructions, Maharaj. Can you have it up sometime? I'll get that instruction. Certainly, certain.
That is a justification, economic stimulus package,
Stimulus,
you are
yes,
giving
yes.
them.
Some, according to my information, Maharaj, with regard to provident fund payment and ESI contribution as well as some
What money?
inter subvention, certain key benefits have.
Our money, they can, my lord, we can take, that's all. No, nothing, my lord.
I will get the
Page
instruction.
number
based on that.
158 at para
I know.
24.
Yes,
I know that, I saw that.
and apart from that, Maharaj, disaster situation,
Now,
which requires.
before labor court, they have gone. After this order of learning single.
No, before that only, they were there
Before
before
that,
the
they
labor
were-
court, Maharaj. Reference
had-
was
Before
made.
the single
Why
judge.
you were before the labor court when there is a notification in your paper?
Why you did it?
No, my lord.
That itself, my lord, shows.
No, my lord. What the Supreme Court said was,
Can't be right on two horses. On
No.
one hand, you are saying that you are entitled to under notification itself. Then where is the need for going to the labor court?
I'll submit.
I think
My lord,
facts,
the
Maharaj.
Supreme Court, in the interim order passed by the Supreme Court, when these notifications was challenged before the Supreme Court, was the interim order said, in the meantime, we are staying this order. In the meantime, parties may seek a conciliation, and in case they are not able to arrive at an agreement, then they should go before the conciliation authorities under Section 12 of the Industrial Disputes Act. Once you go to the conciliation, and if the
Supreme Court gave go by to the notification.
My lord,
Supreme Court gave go by to the notification by providing you to.
my lord, the Supreme Court in its order itself says the right to get wages flows from Payment of Wages Act, Minimum Wages Act, and several acts apart from the notification. That is said in the interim order of the Supreme Court itself, my lord, where it says that because I continue to be their employee. Now, question is, I am not able to earn. I cannot go and work anywhere else. So who should pay my wages is the point. At that point of time, the court said, yes, you can conciliate. You can take 50% of the salary, or you can negotiate and take whatever is amicably agreeable to both of the parties. So in fact, my lord, before the single judge, my lord,
Before learned single judge, the notification was under challenge.
same notification. The points of reference was also challenged, my lord. And the Supreme Court finally passed an order, my lord, after considering everything, and said, we will not interfere with it. That is the final order of the Supreme Court, my lord.
With the greatest respect, that is not the final order. Final order says, go before the appropriate forum. We have come before this court under Article 226.
So you also take a same standpoint. Irrespective of, you establish your claim before labor court.
Yes.
Only thing is, they are relying upon, my lord, this notification. They can't rely upon that
Then
notification.
the Supreme Court has said that all contentions are open. That means that they are not supposed to rely.
No. My lord, it can be raised by the intervener. Constitutional validity can be only decided by your lordship's court, my lord, Article 26 to 27, not, my lord, by the labor court. Simple.
Heard learned senior advocate Mr. Holla for the appellant and learned advocate Mr. You are
I'm Kumar Raman for Union of India.
number one and learned advocate Mr.
AJ Srinivasan for workers, my lord. I
In the
have
facts of
to
the
yet
case,
to get
the
notice.
appeal is admitted.
Interim order has
It
already
shall be
been
listed.
granted.
It shall be
The
listed.
companion petition, my lord, interim orders.
Interim order.
Stay, my lord, of this labor court proceeding.
My lord,
It
the
will be listed for
Page
final.
5, my lord.
It shall be listed for final hearing on 5th of March.
Lord, in the meantime, let the adjudication process
Page
go independent of the notification. Let it go on, my lord. Why should they?
No final order.
Page 5.
No, yes. It's not going to be decided. It takes years for me to get any relief out of the labor courts.
Lord,
Several years, my lord.
Please look at, my lord, page 5 of the memo. Your lordships have granted an interim order already in respect of
Already
the companion. Yes.
5 of the memo.
Yes, my lord, page 5. It starts at page 3 at 5. During the pendency, interim order is pending. In view of that, interim order is directed. Further proceedings before the industrial tribunal shall stand. Page 3, my lord's order. At page 6, my lords get that. 5 and 6. 5 bottom and 6 top. Yes.
Already granted. It will continue. The interim order granted will continue to operate during the pendency.
For
of
this
the-
case, my lord, your lordships will have to be. That's another companion petition.
Different.
Different appeal, my lord.
But then even otherwise, the proceeding stay is granted.
My lord, I had the benefit of a stay before the single judge.
Similar case.
Similar case.
So, as far as the interim, as per the prayer of interim relief is concerned, it could be undisputedly pointed out by learned senior advocate for the appellant that in writ appeal number 1550 of 2024 with IN number 1 of 24, where the set of facts are identical, this court by order dated 22/11/24 has passed interim order directing that further proceedings before the industrial tribunal shall remain state. Post of the said order shall operate in the present appeal also. Please.
Matters may be clubbed together and taken, my lord.
Both the appeals is be listed together.
And I may be served with a copy of the.
This is in fact short matter, but we are unable to decide.
Yes,
That is the reason.
I understood.
We'll conclude on 5th of.
Please.
Very well.
Publish. Notice of admission shall go to the respondent. Notice of the admission of appeal shall go to the respondents who are not represented.
Satish K. APR. But petitioner was kept under suspension on 38/2024 with effect from 9/7/24. 6 months expired, Lord, on 9/1/8/1/2024. 2025. 8/1/2025. 6 months expires. Rule 10(1) Lord B of the CCA rules make it very clear, Lord, if the charge memo or charge sheet is not issued within a period of 6 months, Lord, he shall be deemed to be reinstated. And he shall report for duty
Otherwise also, otherwise he'll be treated as unauthorized absent. Kindly take what? Rule 10(1)(b). 10(5), 10(5)(b).
You are being prosecuted for in crime.
Yes, yes.
So that's a separate, that may be a
That is
separate
separate.
account for continuing the suspense.
Yes.
Irrespective of non-initiation of inquiry.
Yes, but charge sheet is issued. I
Please,
want
my lord,
to-
kindly see page
That memo,
34,
that
my
is-
lord. Page 34, para 3 may kindly be seen, my lord. The case before the learned single judge was that the proceedings in crime number 5/24 was stayed, and therefore they were entitled for revocation, my lord. That was their case before the single judge. That has been rejected, my lord. Now, my lord, the submission being made is that the 6 months has been lapsed now. Now, my lord, if they file a representation, my lord, that will be considered by the government, my lord, in view of the expiry of 6 months.
But 10(1).
Because, my lord, there was a
5B is
stay
very
all
precise.
along, my lord, stay against the initiation of the further proceedings in the criminal.
10(5)(b) is very clear. After 6 months, he will be deemed to be reinstated. Question of Lord, again, Lord, approach, I have approached them. 6 months, that's what, please give me posting. That is also fine, Lord. Serving a copy on the.
That was filed
That's fine.
subsequent to filing of the appeal, my lord.
Yes, my
Recently
lord.
it has been filed. We'll consider that, my lord, as well.
But not the
I
question.
Proceedings in 5/24 are state.
Stayed, my lord. The criminal proceedings have been stayed, my lord, 5/24. Crime number 5/24 is stayed, my lord. During that 6 months period, it was stayed.
But I'm not pressing on that point, Lord. I'm not on that point.
State.
Stayed.
That is called.
Please, my lord.
And
Please, my lord.
The petition is pending.
Please, my lord.
482.
Lordship may kindly, 482 proceedings are pending.
482. Then
But-
he is
but-
justified.
But proceedings are not stayed, Lord. Charge sheet shall not be filed. Proceedings are not stayed. Kindly take
All-
page 154, 184. I produced.
So there will be no further proceedings pursuant to case number 5/26.
Please, my lord.
As per the order passed in the 482.
Please, my lord.
If that is the situation obtaining, he is right in contending that after 6 months, his suspense is liable to be revoked in absence of review.
My lord, representation, my lord, has now been filed. We will consider that, my lord, that is the view taken by the coordinate bench also, my lord. In the similar matter, my lord, identical situation, my lord. Kindly see para 5 of this judgment. No question of automatic revocation, my lord. Para 5 may kindly be seen, my lord. And para 7. my lord. Here again, my lord, liberty has been received.
But in that case, Lord, I appeared, 6 months has not expired. In that case,
3 months. no?
yes, 3 months.
Even in this case, my lord, when the writ petition was filed, 6 months had not expired.
3 months for 6 months.
6 months, my lord. 6 months is the provision under rule.
My Lord, in Ajit Kumar Chaudhary's case, Supreme Court said 3 months currency suspension. Pursuant to that judgment, my Lord, the Karnataka government amended the Lord rule.
Rule 10 says, my lord, 6 months, my lord. Rule 10,
Lord is the time.
5 subclass B, my lord.
Division bench of this court, Lord, examined this question, Lord, held, Lord, the date of suspension is, Lord, on the date of custody. Kindly see that judgment also. 38, Lord, 23, 24, Lord, is order of suspension. Kindly see that. Page 40. English translation is 46. With effect from 9/7/24. So 9/7/24, Lord, is the date of suspension. 6 months will expired on 8/1, Lord, 2025. Representation is made, Lord, because the rule 10(5)(b) says, Lord, deemed to be revoked. If it is not revoked, Lord, I have to report duty. If I don't report duty, Lord, I will be deemed to be, Lord, under unauthorized absence.
So rule 10(3) provides what? After 6 months, automatically revoked.
Automatically, even if it is not revoked, I have to report for duty. If I don't report for duty, my lord, I will be deemed to be under unauthorized sentence.
Third, learned advocate Mr. So-and-so for the appellant, and learned additional government advocates Mr. Harish for the respondent state and its authorities. The challenge in the original, this writ appeal is directed against judgment and order of learned single judge dated 30th September 24, whereby the writ petition of the appellant petitioner came to be dismissed. What was challenged paragraph in the petition was the order dated 30th/8/24 passed by Respondent 1 State Directorate of Municipal Administration, Director Municipal Administration, suspending the petitioner. The suspension was ordered in view of the fact that the petitioner was facing the prosecution in the case registered as crime number 5 of 24. Full stop. Learned single judge took view that the petitioner was caught and the said case was filed, and that since the petitioner was arrested and was released 30 days thereafter, the deemed suspension provision contained in Rule 10(2)(a), capital A, 10 into bracket 2, regular 2 into bracket capital A of the Karnataka Civil Services classification into bracket classification control and appeal bracket over Rules 1957. The suspension was justified. Accordingly, petition was dismissed. Paragraph. When the appeal came up for consideration today, learned advocates for the parties, learned advocate for the appellant submitted that the proceedings of case being crime number 5 of 24 was subject matter of writ petition under Section 482 of the Code of Criminal Procedure 1973, and that the further proceedings of the crime case has been stayed.
No, my lord. What he said is, my lord, final report shall not be filed. That's all. Investigation go on.
That the final report that the court has stayed.
Charge sheet.
Court has restrained the authorities from filing the final report. Full stop. This factum was not, this factum could not have disputed by learned additional government advocate. Full stop. In light of the above stay granted in the criminal proceedings, it was urged, paragraph, by learned advocate for the appellant that Rule 10(3) of the aforesaid rules 1957 contemplate that if the suspension has continued, suspense of a government servant has continued for a period of 6 months and more, and that no disciplinary inquiry is instituted, the suspension shall stand automatically revoked. Full stop. It was the contention that in view of this provision, it was incumbent on part of the authorities to treat the suspension as revoked. Paragraph. Responding to this submission, paragraph, learned additional government advocate submitted that the competent authority is ready to consider the said aspect,
Please,
provided.
they have
the-
submitted a representation.
Already submitted.
Yes,
Yes,
sir.
sir. I have taken representation.
Said aspects, in as much as the representation in that regard is already submitted. Full stop. In the aforesaid view, the following order is passed. The appeal is admitted, it shall be listed for further it shall be listed next on 28th of February. Full stop. In the meantime, the competent authority shall decide the representation of.
Very well.
On that day, petition might become
Infractions.
infractious.
It is not the question, but Rule 10(5) says, may not be impugn order may be stayed.
We have admitted the petition. Let them say.
No, law itself, I will read it, how it is worded.
Then you have made a representation. Let them say
No,
no.
not that. If it is not deemed to be revoked,
Understand, it is automatically revoked.
yes, if
Yes.
it is not revoked, I have to report for duty. If I don't report for duty, I
See,
will,
If you are right, you expect the order that your suspension shall revoke from the date of first day of 7th month.
6 months.
Consider it in proper light.
We'll do that, my lord. We'll pass appropriate orders, my lord, before the next date of
Presentation
hearing.
shall be decided within 2 weeks.
Please, my lord.
My lord may say, my lord, it may come up for admission.
If you
Admit,
succeed,
if it's admitted, my lord, I suspension matter. again, they will not.
Thing of relief, revoking suspension would be allowing the appeal. That will allow at the time of final. Will succeed in wholesale. Where is the question?
My
You know,
only
you're not
request
going
to your
to
lordship,
succeed in part.
give them 15 days time.
You-
They
you-
posted after 15 days for admission.
We have given 2 weeks time. to-
2 weeks. Very
My lord, my request is post it for admission. Instead of, my lord, if it's admitted, my lord, again, my lord.
They will decide within 2 weeks.
Yes,
And communicate, and the decision shall be communicated to petitioner.
please.
If the decision is adverse, you file IA
Very well.
and challenge that decision. We'll decide it on that. If this is in your favor, then you file a memo for withdrawal of
Withdrawal.
the
My only request is, my lord has admitted the appeal. Instead of admitting, my lord may say, may come up for admission. That's all.
No, we are admitting. It will help you in deciding the representative, getting the decided.
It will
Appeal
go
is
to,
admitted.
it will go to final hearing, my lord.
No,
That's
not
it.
go file. Within 2 weeks, they are deciding the representative and communicating to you. Then the gates are open for you to file
May not be-
either IA or what, how can we advise you?
I only request your lordship, my lord, then, my lord, one date may be given at 2:30 after 2 weeks. So that, my lord, on that date, they, my lord, I'll make my submission.
Client will not come to you for filing memo or IA.
Whether he will come or not, my lord, advocate and record will ascertain it.
The 5th February.
At 2:30. So that, my lord, one or other way, my lord, I will make my submission. So that my lord can report to me. 2:30.
5th February.
But-
6th February.
Number 21, Vandana PM.
Advocate and record will, my lord, take the file and delete the name of the respondent too.
So name of both here.
May I, my lord? I'll only take 1 minute, my lord, on the facts. My lord, an order was passed by the BBMP authorities, my lord, in respect of certain unauthorized portion of construction. That order, my lord, was challenged before this honorable court. My lord, this honorable court allowed the petition, quashed. And my lord, against that, a writ appeal is maintained by the BBMP before this honorable court. During the pendency of the writ appeal, my lord, the BBMP authority would once again go out and issue, my lord, have one more proceedings of 248. Now, my lord, a final order comes to be passed under 248 also, confirming, my lord, that there is some unauthorized construction, which was challenged in an appeal before the Chief Commissioner. And my lord, the Chief Commissioner would say, my lord, only this is the portion, my lords, may kindly have page number 74, my lord. Chief Commissioner, my lord, would say this. On page number 74, my lord, observations, my lord, order dated 21/9/2024. Case called out, advocate for appellant present, he praised that notices were never served to them. Later then 27/2/24, the day on which the Honorable High Court in the writ petition number so-and-so passed the order, BBMP authorities sent all 3 orders in a single cover later, denying me the opportunities to be heard. The High Court observation was that the affixation of the wall on the wall is the last resort, and the BBMP undertook to serve the notice by post, but they posted the final confirmation order. Hence, the HC order is itself is violated in spirit. Having gone through the records, it is this case is fit for remand. The detailed order will be passed accordingly, my lord. This is order. Virtually, my lord, the case was decided in my favor in view of the Honorable High Court's order. My lord, astoundingly, final result comes, my lord, the Chief Commissioner, my lord, goes adverse to this very order, dismisses my appeal, which was challenged in a writ petition before this honorable court. And my lord, the impugned order, my lords, may kindly see. An interim relief was prayed. My lords, may kindly have the impugned order, my lord, which is on page number 17. My lord, I'll only read from the 4th paragraph, my lord, on page number 17, last portion. It is forthcoming in respect of stilt ground, and the 2nd floor's deviation is alleged against the construction put up by the petitioner. 3rd and 4th floors have been constructed illegally.
In view of the aforementioned ad interim stay as prayed for only in respect of so and so, it is made clear that the authority is permitted to proceed further in accordance with law in respect of the third and fourth floors. Liberty is reserved. My lord, this virtually, my lord, confirms the action of the BBMP which is under challenge. My lord, the very portion, very order of the BBMP, my lord, the chief commissioner, BBMP, my lord, passed under 248, was, my lord, in question before the appeal, saying that there is no violation, regularization process is there, regularization fee has also been paid. Small apartments, my lord. It's not, my lord, a commercial contract or, my lord, a very, my lord, valuable edifice. It's a small, my lord, apartments for, my lord, the middle class people. Regularization is already sought. And the matter is pending, my lord, was pending before, my lord, the chief commissioner. Chief commissioner observes that the previous order where this very order was quashed has been violated. And, my lord, that is challenged in writ petition. In the writ petition, my lord, the interim stage, the learned, my lord, single judge virtually, my lord, confirms.
Now, what is this one? What is this order dated 29/1? What is the effect of 29/21/9/24 order of this authority?
My lord, this this honorable court, my lord, passed an order quashing the previous round of, my lord.
Where is that order?
This one, my lord, your lordships may kindly have page 46, my lord. It starts, my lord, at page 41. My lord should kindly have the operative portion on page 46. This honorable court, my lord, held that this kind of action, my lord, on the part of BBMP is unlawful.
Action of demolition.
Yes.
So 248 order, final order was passed.
Final order was passed and which was quashed by this honorable court. BBMP has maintained, my lord, a writ appeal which is pending before this honorable court. In the meanwhile, once again, my lord, one more round, as the appeal is still pending, one more round of, my lord, proceedings took place.
Under 248.
Under 248. Final order came to be passed, which we challenged, my lord, in an appeal before the chief commissioner. Chief commissioner on the first day observes, yes, this is totally adverse to the order already passed. My lord, astoundingly, the chief commissioner would dismiss, my lord, my appeal without, my lord, by deviating from the very observations of the chief commissioner.
Dismissal, but it is only remanded.
Yes, my lord, after this remand order was challenged before this honorable court, my lord, the writ appeal is still pending. The BBMP wants to contend that they don't want to, my lord, they need not to follow, my lord, the provisions of 248 by its letters and patent. They want, my lord, some kind of, my lord, that's what, my lord, is the writ appeal which is now posed before this honorable court.
Why should we interfere when the things are, nothing is today finalized?
Nothing, my lord. In fact, BBMP, my lord, has challenged this very order of the learned single judge in a writ appeal, which is pending. In the meanwhile, BBMP would once again go ahead, passed another round of confirmation order, which we, my lord, challenged it before, my lord, the chief commissioner.
BBMC has challenged which order?
BBMP has challenged, my lord, the order passed by the learned single judge of this honorable court on the last occasion.
That is under challenge.
Yes, my lord. Writ appeal is still pending. An intra-court appeal is still pending before this honorable court. And when that is pending, my lord, one more round, which we challenged, my lord, before the chief commissioner. Chief commissioner observes.
So page 74 is the second round.
Yes, my lord. Chief commissioner observes that order is violated.
But then learn a single judge state that order.
In fact, kindly, my lord, look at the impugned order, my lord. The stay is not, my lord. The stay is virtually, my lord, asking the BBMP to go ahead. My lord, page number 18, the last portion, the last but one paragraph. It is made clear that the respondent authority is permitted to proceed in accordance with law with respect to the third and fourth floors. My lord, this, my lord, virtually, my lord, it takes away my right of appeal.
Is it your case that you have permission to construct third and fourth floor?
Only 1(4) was violated, for which, my lord, regularization has been sought. Kindly see, my lord, the
The
last.
specific question is, do you have the permission to construct third and fourth floor?
Earlier, my lord, we did not have. Regularization, my lord, was proposed during the course of the first round of the petition. Kindly see, my lord, the last portion of, my lord, the impugned order. Liberty is reserved to the petitioner to seek for compounding. My lord, this is also pending. Now, my lord, when the liberty is reserved, I have already sought for compounding. My lord, the second but last but one portion of the order, my lord, virtually would let the BBMP to go
No,
ahead
it does
again.
not say so. You see this, it is made clear that respondent authority is permitted to proceed further in accordance with law with respect to third and fourth
Yes,
floor.
Lord.
That is because you did not have permission to put up construction of third and fourth floor, number one. Then liberty is reserved to the petitioner to seek for compounding the illegal construction made. And if such request is made, the authority shall consider the same in accordance with law.
The illegal construction itself was, my lord, third and fourth.
So that means to say, the bare reading of it reveals two facts. One, up to second floor, you had permission to construct.
Yes.
And you have done some excess construction.
Yes.
With regard to that, stay has been granted in your favor, pending disposal.
Which was never, my lord, disputed at all.
Anyway, you are protected insofar as that excess construction up till second floor is concerned. But third and fourth floor, you did not have the necessary permission at all to put up third and fourth floor.
My lord, we did have. Kindly, my lord,
Where
have
is
the
it?
last
Show it.
portion. Kindly, my lord, have the last order, my lord, the impugned order.
No, where is it? Show it.
I'll take your lordship's.
Council, you are permitted to go for compounding.
We are permitted to go for compounding, my lord, but in the meanwhile, my lord, the list is only this, my lord. We are permitted to compound. Compounding process is on. In the meanwhile, my lord, if in respect of, my lord, the observations made, if they proceed, my lord, my lord, the building will be demolished.
So we can interfere to a limited extent by not interfering and saying that the compounding application may be decided.
Yes, my lord. Till then, my lord, no precipitative action, my lord, because the last but one paragraph, my lord, virtually permits them to go ahead.
If your compounding application is decided in your favor, then everything will be halted finally.
Yes.
If it is not, if you reject it, a fresh cause of action.
Exactly, my lord. That's the reason, my lord. Now the impugned order, my lord, the last but one paragraph would, my lord, virtually give them, my lord, go ahead. And, my lord, everything, my lord, would be rendered, my lord, redundant and ought to use.
So dispose of.
Yes, my lord. In fact, my lord, in the writ petition, we have, my lord, challenged. The writ petition, my lord, is still pending. We are only aggrieved by this last but one paragraph of the interim order, my lord.
Then the writ petition will also be over.
I am fine with that, my lord. I am fine with that, my lord. I am absolutely fine with that. Let the compounding, my lord, be considered by, my lord, the BBMP authorities. Until then, my lord, no precipitative action. I am ready to pay fine.
Next matter. You are in next paper, but you are looking as if you are in this.
Karthik, my lord, is very formidable, my lord. I am lucky that he is not appearing again today.
Why can't you prepone yourself? You can prepone your appearance in this matter.
In fact, my lord, I vouch for that. Karthik is very formidable, my lord. I am lucky that, my lord, I don't have much, my lord, opposition today. And at the same time, he is also fair, my lord.
You appear and then respond to what is tomorrow? Please. Tomorrow? Please. Day after.
Lord, may I pray, my lord. Tomorrow and day after, I am traveling, my lord.
27?
27th, my lord.
27, please, at 2:30, please. So
Okay.
only instruction you are supposed to take that within what time you are going to decide the compounding.
Yes, my lord.
Nothing more. Don't apply your mind, please. Otherwise.
Till
there
then,
will
no
be
precipitative action. Till then, no precipitative action.
10 to 27th, learned advocate, Mr. So-and-so is directed to appear on behalf of the BBMP to take instructions with regard to the last paragraph of the order dated 30th, 12/24, impugned in this appeal. Full stop. The appeal shall be listed on 27th at 2:30. Full stop. Till the appeal is decided, no further, till the next date, no further steps shall be taken by the
BBM. So grateful. So good. I'm greatly
authorities.
May only request, my lords,
We'll
copies.
dispose it of, please.
Copies to be served on. Copies to be
We
served.
will serve, we will serve. We will serve on Karthik.
Ready notice matter. Still number 22, writ appeal.
Lord, I appeal for the fourth respondent. Pray for short accommodation. Senior is not well.
You for reading.
Appellant, my lords. Let us pray for short accommodation. Senior is not well. My senior is not well, my lord. Pray for short accommodation,
Senior is not well.
please.
You are for corporation.
I am for the appellants, my lords, private parties.
Private part.
Fourth respondent is the corporation, city
You are
municipal
for
corporation.
corporate.
Please. Writ petition filed by the fourth respondent.
When you will,
Next week.
next week. Twenty-ninth January,
Please. Put it on 30th.
30th,
Please.
30th January.
Please.
As requested by learned advocate for the respondent. Corporation.
Corporation.
To be listed at 2,000.
Number 23.
My lord, in this matter, we entered into a joint development agreement in the year 2006. The developer put up construction without obtaining approved building license, my lord, which is why the respondents issued notice for demolition of the illegal construction, my lord. And thereafter, we made representation as well, which was not considered by them. And then we filed WP number 7178 of 2021, my lord, seeking a direction to consider the representation and to pass appropriate orders. My lord, the writ petition was disposed without any direction, only because we did not make the developer as the party. And thereafter, we approached the developer and then we found out that he died. And then we approached the wife as well, only to negotiate remedies to regularize the illegal construction. And even then, she was not aware of anything, and hence there's a delay to file the appeal, my lord.
There is a delay of 511 days.
Yes, my lord. Only because of that. I'm only seeking a direction to consider my representation, my lord, and to pass appropriate orders.
The order was passed in 23.
Yes, my lord.
How come that 511 days?
My lord, we approached the developer after that, and then the developer, we found out that the developer died.
Even then 511? It can't be 511 days. It must be less, even if it is delayed. It is filed on 14/8/24.
Yes, ma'am.
In 2 years. 65. That's it.
It was not intentional, my lord.
What is the representation given by you
That is in page 66.
to BBMP?
Yes, my lord.
65.
To 66, my lord. That's the typed copy. Stating that I'm the owner of those sites, but then I entered into a joint development agreement. And as per the agreement, the developer was supposed to pay, obtain license and also obtain approved building plan as well, my lord, to put up construction, which he did not.
May only draw my lordship's kind attention to page 13 and 14.
Virtually request to the authorities concerned to demolish the building. This is the one of the interesting to then on the ground, then she cancels where the dispute, she cancels and development. And also makes a representation to the BBMP to demolish the building by as the same. He put up in violation of building. She does not see. So you have. She gives a representation, saying that. A representation page number?
66, my lord.
67. By being the one of the aforesaid sites and being the law of the section and not modification and verifying the question.
So you are, she is for.
Yeah, she is for the owner and demolition, but she does not include the developer in the proceedings. Actually, she is asking BBMP to demolish the building, which is put up by the developer. Rights will have vested in favor of the developer.
The petitioner has entered into a joint development agreement. The petitioner has entered into a joint development agreement with the builder, my lords. It is there in their own representation. It is in their own representation. And now the petitioner claims that in their site 96 and 97, a builder is building without setbacks, my lords. Without leaving any setbacks or taking any plan approval, my lords. And my lords, this honorable court, my lords, in page number 14, if my draw my lordship's kind attention, has clearly pointed out that the developer has not been made a party.
And developer is.
And the list has to be decided by the trial court, my lords.
There's nothing wrong with the article. Nothing wrong. There's nothing wrong with it. 4 uses.
So delay condoned, appeal dismissed.
Number 24. Hello.
I'm pressing on EA, my lords, for conduct of the examination which has been missed, my lords. The lordships have already granted an interim order permitting all the students to appear in the examinations.
Lord, as it stands, the writ appeal itself has become infracture. Where is the question of, Lord, this is the final order that has been passed already at his behest.
What is this? Which are these orders?
But this is an order regard to a fifth attempt beyond the 4 attempts permitted under the law. An interim order had been passed. Thereafter, my lords had passed an order permitting the students without claiming any equity. And thereupon, this order came to be passed as the final order.
In the very petition,
Pardon?
in the very,
In the very matter, in the very writ petition. Therefore, this writ appeal, as my lords had earlier pointed out at one occasion in the past, that nothing survives for consideration because the limited aspect was the interim order. If the interim order is effaced, not only it merges, but it is effaced. You have to file another petition if at all anything has to be done.
It would be a formality, my lords, but.
No, it's not a formality. It's not a formality.
Just answer, lords. Because, my lords, the interim order under appeal itself was, my lords, answering all the contentions raised by the petitioners. The entire writ petition as of the interim order was, my lords, answered. Kindly see, my lords, the order now which has been passed in the final order, my lords. My lords, your lordships would find the order that has been passed. Last paragraph, lords. Very last paragraph. Last page, last paragraph.
On page 21, the last para, not the last para, the
Just
third
the
last
last paragraph would be
para
relevant.
number 3.
Absolutely relevant.
one second. So it was under against the interim order that this appeal was.
My lords, there was a confusion, my lords, as regards the order itself, because, my lords, we had filed the appeal as though it was a final order because it was dictated as though it was a final order. Order copy was not released. We had moved the writ appeal without the order copy.
That is all right, but
Yes.
the order which was impugned was an interim order.
Yeah.
Where is that order?
My lords, interim order is that page, my lords.
Page 24,
Correct. It is page 79 is the final.
final line, yes.
That is in the same writ petition. Yes, so now
Yes.
what survives?
Nothing so.
My lords,
can-
your lordship said, I will challenge, my lords, by formality, my lords, this order.
It's not a
But
formality.
this
Point
writ
out
appeal
why-
will still need to be kept pending, my lords, has to be heard together for the reason, my lords, your lordship's interim order. Your lordships have granted me an interim order in this matter. Your lordships may kindly see your lordship's interim order on 5/12/2024. Paragraph 2, my lords. Paragraph 2 of the interim order. While it is true that the order brought under appellate jurisdiction is an interim order and in normal circumstances, the court would not entertain a writ appeal against the order, which is an interim nature. However, the present order finally denies the.
It is for the
Transfer
purpose of
appeal.
entertaining the appeal, that it has the traits of finality.
Finally,
Doesn't say.
Nothing survives here.
may I
He has
request
to make
only
a-
this, my
He
lords?
has to seek fresh
Kindly
admission.
have this matter, my lords, on Monday, by which time, my lords, my other appeal also I will bring it up. Lords. Okay, both appeals can be heard together. my
No,
lords.
my lord,
This
that
the-
is not the point. It cannot be.
Because your lordships have granted me an interim order here, my lords, it would.
You can seek again that prayer.
Yes,
Absolutely.
yes.
That's all.
This
Yes,
has
my
to-
lords, my only request.
They are not,
No,
nor denying your prayer, nor taking away right to pray again.
That's right.
Absolutely, my lords. I bow down to that. My only request, my
Becomes
lords, kindly be
infructuous.
had on Monday. I'll have both the appeals present because facts
This
here, my
has
lords,
to
would.
go as infructuous.
Why, my lords, I've already placed all the documents that are relevant in this writ appeal. In the other appeal, my lords, and for fresh notices to be sent to all institutions who take considerable amount of time. For which, my lords, I'm asking, I'm praying for urgent interim orders. For that reason, my lords, kindly
That
keep
can
this
be
appeal
ordered on the
pending
councils.
till Monday, my lords. The other appeal also, I will bring it up and I'll pray for the interim
But
order.
we will
That
say
is-
that you are entitled to the very relief which is granted by the interim relief.
That's right.
But
But
now infractuous.
Notice and, my lords, further notice would take time. That's the only, my lords, concern that I have.
Oh, my
So
lord,
for
that
that
is-
for that reason alone, my lords, I'm asking.
Well, that is presuming that he is entitled to admission.
Absolutely, absolutely. Presuming, yes, my lords.
No, no,
I've
there
done this
cannot
to
be
the
a
court of-
presumption. That is the big.
Appeal number 1771 of 24. This appeal arose from order dated 29/11/24. Which was an interim order passed in the group of pending writ petitions for a single judge. While challenging the said order, the grievance of the appellant petitioners was that they were entitled to appear in the examination of the subjects concerned beyond 4 attempts.
Yes, beyond 4 attempts.
As the learned single judge had negatived the said prayer in the said interim order dated 29/11/24, the cause had arisen to file writ appeal, instant writ appeal by the appellant. Paragraph. In the writ appeal, order dated 5/12/24 was passed, and the petitioners were permitted to appear in the examinations which were to be held on 6th, 9th, 11th, and 13th December 2024.
Without claiming any equity.
At the same time, it was observed that the factum of appearance of the petitioners in the examination shall not create any right or equity in their favor, and that the result of the examination shall not be declared without the permission of the court. Paragraph. During the pendency of the appeal, it appears that the main proceedings of the writ appeals, writ petitions, came to be decided by learned single judge, and final order therein came to be passed on 16th December 24. When the present appeal came up for consideration today, copy of the said final order dated 16th December 2024 was produced. In the aforesaid view, and the parent proceedings are already decided, and this appeal was against the interim order in those proceedings, the appeal substratum of the appeal would not survive, and it stands disposed of as not surviving, having become infructuous. Paragraph. Learned advocate for the appellant harped that interim order was passed on 5/12/24 to the benefit of the appellant students in the present appeal, whereby the students were permitted to appear in the examination, and that said relief
Further
that
benefit.
the said grievance and that the said issue still remains alive for the petitioner to be agitated in the present appeal. Full stop. The court fails to appreciate the submission inasmuch as when the main proceedings are concluded, the appeal against the interim order would not survive. Paragraph. The order of learned single judge, paragraph, dated 16th December 24, disposing of the petitions finally would give a fresh cause of action to the appellant. Full stop. It is for the appellant to consider filing of appropriate proceedings in accordance with law, if permitted and if advised. Full stop. It is clarified that if such proceedings are permitted in law, the such proceedings as may be permitted in law, in such proceedings as may be permitted in law, it will be open for the appellant petitioner to pray, make all the prayers.
My lords, my lords may kindly note, my lords, the final order only refers to, my lords, the earlier interim order.
But that way, if I start
Kindly
arguing.
last paragraph of that order, if you lordship.
Final order.
Nothing else was decided, my lords, by the final order, except referring to that all questions are answered in the interim order dated 29/11/20. Nothing further survives the matter is the only observation.
That is not the thing. There is something
Technically-
more that we will submit when
absolutely
it comes
nothing,
up.
Technically appeal with.
Only on technicality.
It's not only technicality. But when an interim order is passed, which is adverse to you, you go back to the learned single judge and say, dispose it off on the same lines without arguing it. Please ponder over it.
Kindly, my
The
lords.
learned friend should ponder over it. my lord.
Absolutely
He
nothing.
should argue it and get the interim order reversed.
In fact,
That should be his agenda for
Not at
the
all.
final arguments.
my lords, we had
Instead, he
addressed
goes in para
final
3.
argument before. the
Please see
learned
what he
single
says in
judge.
para 3. He says,
council
Lord,
submits that the only relief that the petitioners had sought in the other petition is as regards the number of attempts, and that is stood answered. So I am quite happy with the interim order, and therefore nothing remains,
This
and
is-
therefore nothing
this is
survives for consideration. This is
There's
his
nothing
submission.
there except, my lord,
Therefore, he has to
All
first cross
arguments
the
were
hurdle of
advanced.
filing the appeal, let it come for admission. We will see whether it is res judicata. It cannot survive because he
Lord,
has already,
I will still have to file another appeal challenging the very same order.
He
My lord,
says
the very
make
same
rule
interim
absolute.
order 29/11/2024 will have to be challenged.
Payments
said
have
make
started
rule absolute.
Payments have started before you filed here.
My lord, we get an opportunity sometimes before the court, my lord. Or this court.
We are not concerned with all this. We are concerned with the disposal of the.
Yes, my lord, yes. Only thing is I'm putting my learned friend on the principle.
My lords, NMC, my lords, we will show the conduct of the NMC before the learned single judge in these proceedings as well as, my lords, connected petition
So
proceedings.
last line is that
Where
we open
different
for the
stands.
absent petitioner to make all the prayers as may be available in law in the press proceedings which may be filed on the basis of the press cause of action as indicated above.
Great, my lords.
Right? More clear.
The last part.
Yes,
Didn't quite get the last.
liberty to raise the very same questions that I've raised here.
Same.
Yes, that's all.
Number 25.
Liberty, if my lord writes, up to that last point was okay. Liberty
Yes.
means my lord is saying something more.
Yes.
My lord is giving liberty. That means my lord is going beyond, beyond what has been said.
Liberty to pray is no liberty to grant. Isn't it?
No, no, liberty is given. That means it will be said that what I had urged earlier, I am given liberty to urge again. So my lord had closed.
In such proceedings, contention of both parties will be open.
contention
All the
will be-
contention of
not
both
liberty.
sides will be open.
My lords,
Not liberty.
he can't, my lords, now
Liberty,
say
liberty is
that the matter
positive.
has become infructuous and then come back in
No, no,
new
that is
appeal
for
and
us
say
to
it is res judicata.
That is to be argued at
No, my
that
lords,
time
that
when
is,
you
that is
file.
what, my lords, I am trying to avoid. Your lordships may kindly grant me liberty.
That is-
Otherwise, my lords, I have to raise.
Whatever is done, whatever is done. No change of any language now. Yes.
Yes, grateful.
Number 25. CM Venkat Reddy.
Correct. Serial number 25. What happened to the proceedings?
My lord, the proceedings are posted tomorrow. My lord, I've kept the additional Deputy Commissioner present before my lords. He seeks for some time to conclude the proceedings and my lord to submit the order before my lords. If my lord were to grant.
It was submitted and when the petition came up for consideration today, from a learned additional government advocate, Srimati Nilofer Akbar submitted that the proceedings
Under 67.
referred to in order dated 12/12/24 are still pending and are likely to be concluded within short time,
2 weeks, my lord, and the presence of the special DC may be noted.
within two.
It's on his instructions
within
and
two-
making submission.
Within 2 weeks or within 2 or 3 weeks, full stop. This statement was made in presence of
The special Deputy Commissioner, Mr. Balakrishna.
Mr. Balakrishna, holding the post of Special Deputy Commissioner, before whom the proceedings are pending.
Yes, yes.
Full stop. In that view, the petition shall stand over to 6th of March. 6th
Lord, my lord, February.
February,
Yes,
19th February.
obliged.
This is number 26. PV Nidhishri.
My lord, I appear for the respondents in this matter. My lord, this pertains to providing of, my lord, infrastructure facilities, my lord, for a short distance of 825 meters, my lord, of a state highway. My
Lord,
lord,
this is where they have acquired the land in the guise of impending acquisition of land. Footpaths have been gutted, sewage lines have been gutted, drainage has been gutted, and they've been living like this for the last 5 years, my lord.
My lord, may I make one submission, my lord? My lord, no doubt, my lord, proceedings had been initiated, my lord, to acquire lands, my lord, acquire houses which were on the either side of this 825 meters. My lord, aggrieved against, my lord, the land acquisition. My lord, proceedings have been initiated before the Dharwad bench, my lord, which is posted on 23rd, day after tomorrow. My lord, there we are, my lord, expecting a compromise to be arrived at between the owners and the government. my lord, and thereafter, my lord, the proceedings can be taken forward. My lord, I'm filing the affidavit of the Assistant Executive Engineer, bringing to my lord's notice this fact and the exact condition of the roads, my lord.
So those proceedings are between the private party,
Yes, my
private
lord.
dispute.
Yes. No, my
But
lord,
that
proceed for acquisition, my lord, the special DC had initiated proceedings under section 11A of the Land Acquisition Act, which is being challenged before the dishonorable court, my lord, Dharwad bench. My lord, that is posted day after tomorrow, my lord, to report compromise. My lord, once compromise is arrived at there, my lord, then the proceedings will be initiated because we'll be able to demolish those portions of the houses. My lord, pay the compensation. Yeah. Sorry.
So we'll be acting upon the prayers in this petition after disposal of this.
Yes, my lord, and we will see how things go there before the Dharwad bench, because once if they compromise,
So we'll not observe anything, we'll simply put off the.
yes, my lord may grant us 3 weeks time and then I will get, otherwise 2
Ladies will
weeks,
go.
my lord, 2 weeks.
My lord, this seems to be going forward on one ground or the other. The reality, ground reality is that the people who are living there currently, who have nothing to do with the acquisition, or nothing to do with the compromise that is being arrived at, they are living there under the sword of disease, and mosquitoes and dengue and sewage lines are open, etc. At least if some basic facilities are provided, my lord.
My
they're
lord,
not asking
unless
for
the
anything
land
else.
is acquired, my lord, how can we provide drainage? How can we asphalt the road?
Private land.
This is
Yes,
the
my
main
lord,
road. This
houses
is not
on each,
private
my
land,
lord,
my lord. This is the
madam,
main
can I
road.
bring to my lord's notice the small stretch which I want to?
This
It'll
is the
be-
main road of Badgi.
But then we'll not grant longer time.
My lord, that's why I'm asking for only 2 weeks' time. I'm not asking for a long adjournment. 2 weeks, my lord may have it. Then I'll be able to apprise my lord as to what has happened. In case if the compromise has arrived at,
4th February,
obliged, 4th,
February,
my lord, 2 weeks.
2 weeks, more than 2 weeks.
Very well. I'm sorry, my lord, I didn't see the.
Yeah, the Lieutenant Additional Government Advocates will be local record files affidavit, which is taken on the record. In view of what is submitted by her, so must tend over to 4th February. On which date she will apprise the court about the further development.
Number 27. That's 27, I appear for the petitioner. Lord's matter pertains to illegal construction by respond number 9 by encroaching road area. This honorable court, after hearing the parties, had directed spot inspection to be conducted by the ADLR. At this honorable court, my lords, had directed spot inspection to be conducted by the ADLR, PWD officials and other officials of the state government. And they have filed a report, my lords, on 31/7/2023. It has been placed and it has been shown that there is an encroachment of the road area. And report has been placed before your lordships.
We have filed our objections. There is no encroachment. Matter of, my lord, 1985, my lord, construction. The government, my lord, commercial department was a tenant in our premises for 15 long years. Where is the encroachment? I don't understand.
You filed the objection.
Yes,
Filed the.
yes, I filed.
They have already filed. They have filed.
ಯಾವತ್ತು ಹಾಕಿದ್ರಿ objection?
So your response number?
9.
Nine,
my
my
lords.
lord. 9, August 23, ಏನ್ August? 23rd of August. 23rd August ನೋಡಿ. ಸೀಲಿಲ್ವಾ?
ಏನ್ ಮಾಡೋದು ಹೇಳಿ. My intestines, I think, are getting displaced.
It is a commercial building.
Yes,
Yes,
my
my
lord.
lords.
Constructed, my lord, way back in 1985. Plans and all that we have produced before your lordships. It's a absolutely, my lord, frivolous petition. There are some disputes, my lord, between the partners of this firm and them. So, my lord, he engineers this.
My lord, every department of the state government have filed a report stating that there is an encroachment.
Hmm.
Till date, no action has been taken. That is why we are before this honorable court. And the situation is such that, my lords, if I may take your lordship's kind attention to one photograph which I have produced.
If your lordships come to, my lord, page 39, commercial department, my lord, was an off, my lord, tenant, please come to page 39. First floor. Commercial tax department, my lord, was a tenant. Second floor, third floor. And this was, my lord, in the year 1999. Your lordships get.
Special notice, special notice.
It's a special notice issued, my lord, on 30th of November 1999. I'm sorry. The date, my lords, get that at page 38, Kannada translation. My lord, here they have not typed it out. My apologies, my lord.
Which is the date? Which is the date?
Date is, my lord, 30th of November 1999. So, my lord, from 99 onwards, commercial tax department.
Where is the finding he is indicating that it is encroachment?
Let's report of the
Report,
ADLR may kindly be perused, my lords, on dated 31/7/2023. It's a separate memo, my lords.
Separate report.
The PWD officials, the Davangere Corporation, as well as the ADLR, all were present and they have conducted a spot inspection report.
So some part is illegal. Some part is illegal.
No, my lord. It can't be. This is, my lord, that's why, my lord, we have filed detailed objection. Now, please come to, my lord, my photographs.
Some part, that is what is indicated.
85, my ground floor was constructed.
Government department. Government departments are functioning. This is the enforced portion.
1985, the first plan, my lords get that at document number 9, 1, page
Will-
10 of my objections.
Will continue.
Yes, yes.
Serial number 36, my lord. I am for the petitioner. Government advocate has just now given the copy of the objection. And any date may be fixed, 2 years. Serial number 32, my lord.
Court officer, sir.
Number 27.
For the petition.
Please have a look at the objection statement for that we have filed. First, my lord, ground floor was constructed in the year 1985. Page 10 of the objections. This was, my lord, in the year 1985.
This map,
Yes, my lord.
page 1.
Lord, it's at the plan, my lord, which is. Sorry, my lord, objections to the report of the
2023.
Page N,
10, my lord.
N for
10, my lord, 10.
10.
Yes, that's,
This one.
yes. This is, my lord, approved plan in the year, my lord, 1985, 2/12/1985. In the middle, my lords get that. I'm sorry, it is in Kannada. In the middle, my lord, after the building plans are shown.
6/12/9, 6/12/85.
85. Then, my lord, please come to, my lord, page 11. There is a commencement certificate, page 12. As per the provisions of the Karnataka Municipal Corporations Act, or, my lord, the Municipalities Act, we are required to, my lord, take a commencement certificate, my lord, for construction. My lord, when we start the construction, we will have to put the 4 pillars. Basement, my lord, the ground, my lord, the foundation has to be laid, and then, my lord, they permit, after inspection, that it is within the plan, they give, my lord, what is known as a commencement certificate. The planning authority has given the commencement certificate at page 12 for the ground floor. Then, my lord, please come to, we, my lord, obtain a plan, my lord, for the upper floor. Page, my lord, 22. My lords, at the bottom, my lord, right, extreme bottom, my lord, get the date, 29/9/1990. 12/22, my lord.
The map,
Yes, my lord. That's a building plan, approved building plan by the for the first and second floors. Then, my lord, the commencement certificate, my lords get that at page 17. After, my lord, the plan is obtained. Then, my lords may come to, my lord, the 3rd floor, which your lords get that at, my lord, running page
27.
28.
This was second floor.
That was the first and second floor. First was ground floor 85. Then, my lord, 1992 was first and second floor. In 98. 3rd floor, my lord, is page, my lord, 28. The commercial tax department itself took the premises on lease. My lords get that at page 39, which I pointed out in the morning. 39, my lord. 39. And we have the lease reach, my lord. Only thing is it's all in Kannada, my lord. We the translation. My apologies. My lord sees, my lord, page 39. This is a special notice issued by the City Municipal Council itself. Name of the occupant. First floor, commercial tax office. Second floor, commercial tax office. Third floor, commercial tax office. This is, my lord, in the year 1999. They wanted to widen the road. They found, my lord, that road widening, my lord, was opposed. In fact, my lords may come to, my lord, page 62 for a minute and tell your lordships why. Because the sketch, my lord, which was prepared, the survey report says 120 feet, my lord, is the width of the road, my lord, it's actually 81 feet. Please come to, my lord, page 62. This is the PT sheet. Pune Bangalore highway, my lord, on the left side bottom. Please look at, my lord, the note. This is to certify. Sorry.
Page
62, my lord.
there is some paging difference, but it is.
My lords may come to the bottom, my lord, absolute bottom. This is certified that I've gone through the PT sheet, pertaining to the PT sheet number 46.
This is to certify.
Yes, my lord. City survey as requested by Tipesh, door number so-and-so. And I made digitization of the PT sheet, made measurement of the PB road, so-and-so, and confirm that the width of the old PB road is 24.69 meters or 81 feet. There, my lord, the survey report, my lord, that survey sketch, they say, my lord, it's 120 feet, my lord, and I'll point out. Please come to, my lord, page 65. They wanted to, my lord, increase the road width because earlier it was a national highway, now, my lord, it has become a state highway. So nothing is needed also. Can I persuade your lordships to, my lord, come to the order at page 96 onwards? All right, my lord, I'll not even trouble your lordships, my lord. Please come to, my lord, page 99. That national highway gave you no objection. It is. Then, my lord, this, they say, my lord, that, any action, they will not, my lord, they will not permit any encroachment. More important is when they wanted to widen the road, please come to 101. Unless you acquire the property, there is no question of your widening the road is what they said. They had, my lord, a proposal to widen the road. Please come to, my lord, page 105, the order portion. Petition is disposed of in terms of the aforesaid decisions of this court in the case of Chuba versus so-and-so. And Rajgopal Reddy versus so-and-so. Liberty is reserved in favor of the respondent take appropriate steps against the petitions in respect to scheduled property following due process of law and as per the decisions of this court, referred to supra. And what was the order, my lord? Before demolition, or, my lord, page 104, you will have to issue notice, give compensation.
Just liberty is reserved on the council.
Yes, my lord. They can do it, no difficulty, but they have not done it at all. Then next one also, my lord, is same, 107.
So this page 103.
Yes, my lord.
Prayer is that declaring that the Action of the respondents to demolish the portion.
Not mine, my lord. This is mine, yes, correct.
Here. So,
They said, if there is anything, because my lord, there was a proposal for widening of the road.
so that the very portion which is indicated in map.
Not that, my lord. Please come to 100 and, my lord, 103, please come to bottom. I'll tell you a lot. In this petitioner, 103, my lord, bottom.
Here.
In this petition, petitioners have sought for the following reliefs. Issue writ of order or direction or any other writ, appropriate writ, declaring that the action of the respondent to demolish portion of the building existing on the scheduled property to this petition, without following mandatory provisions contained under the Right to Fair Compensation and Transparency in Land Acquisition and Rehabilitation Settlement Act of 2013, payment of compensation as provided therein, as one without jurisdiction, without authority of law. Issue a writ or order direction prohibiting the respondent from demolishing portion of the building existing on Schedule A and B properties to this petition, without acquisition and payment of compensation as provided. Please come to my lord, page 65. I'm not the lone person. There were, my lord, page 65, if your lordship sees. Number of persons, my lord, came before the court. Page 65, my lord, onwards, till, my lord, page 100 and, 94. Nearly, my lord, about about, my lord, 40 people who are all, my lord, situated in that road. They all came before the court saying that you can't demolish the building without notice, without paying compensation. That's what, my lord, the division bench held. Yes, you'll have to pay compensation. I also came, my lord, thereafter because I was not a party there. They also said, if you want to acquire, you will have to pay compensation, issue notice and take over. My submission to your lordships is, please come to, my lord, running page 129 now. This is, my lord, the building line. My property, my lord, is here. It's all in the same line. There is no encroachment. The first, my lord, if your lordship sees, the first building, my lord, with that, the first one, my lord, yeah, that is my building. My lord, it's all in the same line. White building, yes, my lord. Not the earlier one, but the second one, as your lordship sees, my lord, there is a hoarding, red hoarding. That's my building. It's all in the same line. There is no encroachment. And, my lord, this petition is a motivated one. I'll tell your lordships why. Please look at, my lord, the prayer. He wants, my lord, the building to be demolished. Not only that, if your lordships now look at in the background of this, please look at, my lord, the report. They are saying, my lord, the width of the road is 120 feet. Width of the road is only 81 feet. Please take, my lord, the report itself. Report says from the middle of the road, my lord, 60 feet on either side. It will be 120 feet. Actual road is only 81 feet. And construction was, my lord, way back in the year 1985. Where is the encroachment, my lord, I ask myself. And please look at the prayer, my lord, that has been made. That's more important. Please look at, my lord, main writ petition. Look at the prayer. And the proposal for widening, my lord, has been given up. Page 21 of the writ petition, my lord, if your lordship sees. He suppresses every material fact. Page 21. Issue a writ of mandamus, sorry. Or the writ petition, my lord. Yes.
Page 21 is.
21, my lord. That's what, my lord, what they have given me.
Of the writ petition, it's 21. 21, my lords, of the writ petition. My prayer is in 20.
Issue a writ of mandamus or any other direction, directing the respondent, demolish the building bearing number so and so, insofar as it violates the building plan. My lord, I ask myself, where is, my lord, where have I violated the building plan? The government itself has taken it, my lord, after PWD inspection, that my lord. Then issue a writ of mandamus to initiate disciplinary action against so and so. Demolish, my lord, they did not even produce before your lordship the fact that, my lord, 1985, the plan was sanctioned. I constructed the building, my lord, ground floor. 92, my lord, the first and second floor. Everything was suppressed. After 35 years, my lord, they come before your lordship, my lord, for demolition.
But then why this court has kept it open to take action in that one of the order?
My lord, please look at it. That was because, my lord, they had an intention to encroach, my lord, extend the building line to 150 meters. My lord, can I persuade your lordship? Just look at.
It was not your petition.
There are about 40 petitions, my lord. 40 petitions were there. Because all the persons, my lord, on the Pune highway, Pune-Bangalore highway were there. Now, my lord, it has become, my lord, a state highway, not even a national highway. It has ceased to be a national highway. Please come to we have produced that also. Statement of objections, my lord, that we have filed to the.
Now, what about the third prayer in the petition?
Third prayer, my lord, is.
It will not survive.
No, my lord. Mandamus directing the respondent authority to expeditiously complete the road widening. Now they have given it up. State, my lord, has to say anything, whatever they want to say. State had given it up. In fact, there were certain, my lord, meetings. They found that, my lord, they'll have to demolish something like 240 buildings, including some government properties also. So they gave it up.
Page 55 meeting.
Page 55 of, my lord, the objections.
To commissioner report.
To the commissioner's report itself, my lord, she says all that. Lord, I've prepared a short synopsis, my lord, just to assist your lord.
Lordships, if I may.
Court must. In fact.
Your Lordship, if I may point out two documents.
Can I persuade your lord, look at page 40 of the objections to that report, survey report. National Highway itself gave us, my lord, permission to, my lord, to construct that third floor. Please have a look at it, page 40. Or the objections to, my lord, that commissioner's report. Page 41. Forty is Kannada, my lord. 41 is the English translation. (1997), my lord, my lords may recollect that 1998, my lord, I constructed the third floor. Before constructing the third floor, I went to the National Highway authorities themselves. Sorry. 41, my lord. granting permission to construct the building over the existing building in PB Road to me, my lord, Ruddappa and Company. With reference to the subject and reference cited above, we have no objection to you to construct the building on the existing building as per conditions prevailing over the National Highways Act. In 1997, they have given me this. My submission is everything was suppressed. In fact, my lord, the Honorable Supreme Court, my lord, can I give you a lordship, my lord, two judgment, my lord, for my lord's consent? And they have also violated the rules. PIL rules, my lord, have been, my lord, have been totally ignored. Please look at, my lord, 3 judgments. They suppress every material fact. I have set out, my lord, what are the material facts, my lord, they have suppressed in my petition, my lord, my list of dates and synopsis. First judgment, if your lordship is 2005, 1 SCC, 1998, 6 SCC, my lord, in all these matters, PIL, if they suppress material fact, is liable to be dismissed. In case of delay, in this case, my lord, 35 years, my lord, they have come. 1985, my lord, I completed. They come, my lord, in the year 2021. Even PILs file, my lord, after 20 years, 10 years, 20 years. In fact, in that airport authority, my lord, Ramanadaya Ramashetty's case, my lord, 5 months delay. The lordship dismissed it, saying that by then, my lord, he had already, my lord, started the restaurant. Now, my lord, more important is, they have violated, my lord, the rules, my lord, framed. Please look at, my lord, the last judgment for my lord's consideration. 2022, SCC Online SC 1541. Page 73, my lords, get that. At, my lord, page 22, sorry, 82, para 22. Honorable Supreme Court, my lord, has directed that all, my lord, High Court should frame rules with regard to, my lord, the PILs. They have to indicate, my lord, what their credentials are, whether they have filed, my lord, earlier any petition. They should not suppress material facts. All that, my lord, parameters are listed out. Everything is violated here. Please look at para 22. No doubt the above procedure given, my lord, this was the High Court, my lord, framed the rules in terms of the Supreme Court order, page 82, para 22. I've listed out, my lord, one small, in the beginning itself, which paragraph, what it is. If my lords come to the middle, my lord, about 2, 3, 4, 5, 6, 7, 8 lines from the bottom, my lord, of para 22. To the contrary, Jharkhand High Court has held Rule 4, 4A, 4B, 4, 5, of, my lord, the PIL rules of Jharkhand High Court are not mandated, but directory in nature in view of Rule 6A. And therefore, even though the rules have not been followed, that really will not come in the way of the court to entertain PIL, since the nature of allegations in the PIL are serious nature. This reasoning, in our view, is in the teeth of the decisions of this court given in Balwant Singh Chapfal, that is, my lord, that 2010, where, my lord, the Honorable Supreme Court has given direction that rules have to be framed, my lord, in relation to PILs. Lastly, my lord, please come to, my lord, the judgment at page 88. The division bench of this Honorable Court, my lord, His Lordship Justice Varale, when he was here, had, my lord, an occasion to look into it. Para 14, my lord, at running page. (105). Para 14, as observed above. Sorry. As observed above, petitioners did not disclose the credentials as per clause B of Rule 11 of PIL rules. Further, the petitions have not satisfied regarding the correctness of the contents of the petition, as petitions have suppressed regarding the pendency of criminal case against petitioners 1, 2, 3. Also, writ petition number so and so in the petition. Thus, the petitions have failed to comply with Rule 11 of the PIL rules. Ultimately, my lord, their lordships, my lord, dismiss the petition, page 107. My submission is here they have suppressed every material fact. In fact, my lord, I have listed out what are the material facts they have suppressed in my list of dates, my lord, and synopsis. They suppress, my lord, please come to, my lord, serial number 18 at page 6. Mandate requirement of, my lord, public interest litigation rules have not been followed. without which the writ petition itself is not maintainable. All that, my lord, I've said out everything. That's all. Grateful.
Lords, if I may. With respect to the separation of material facts, my lords, in my petition itself at page number 30, my lords, if I may point your lordship's kind attention. There, the Davangere City Corporation itself has given a report stating that the building has encroached 7.64 meters of the western of the building encroaching the National Highway 4. This is the report given by the Davangere City Corporation, and several such reports have been given to the Anti-Corruption Bureau also by the PWD officials. My lords, based on these reports, I have approached this honorable court. There is no question of any separation of material fact, because if any documents which they have in their custody with respect to their building, it is their responsibility to produce it. So there is absolutely no question of suppressing any material fact. It is certified by all the government departments that the building has encroached the road area. Secondly, my lords, at page number 28 of the statement of objections which they have filed, the building sanction plan. In the building sanction plan itself, the road width is shown to be 120 feet wide Pune Bangalore Highway Road. Therefore, the building sanction plan itself provides that the road is measuring 120 feet. So there is no question of the road being 81 feet. So this being the fact, my lords, and pursuant to considering all these submissions itself, their contention on the earlier round of hearing was that they were not present when the inspection was conducted and the report was given that there is an encroachment. When in their presence, when the measurement was done, it was found to be encroaching the road area. Thirdly, my lords, if I may take your lordship's kind attention to page number 98 of my petition. Page number 95, if your lordships may kindly peruse. The photograph which I have produced, my lords.
Five.
95, my lords, of my writ petition.
Writ petition.
Yes, my lords. Lords, as pointed out by the learned senior counsel, that is not the building in question here. The building in question is this, and if your lordships may kindly
Same.
consider page number 98, my lords.
Hmm.
98, my lords. All other buildings, my lords, page number 98, my lords, if your lordships.
Different page numbers in different sections.
Annexure Q3, my lords. Annexure Q3.
Photographs are different.
Annexure Q3, my lords.
Q3 is this.
Yes, my lords.
So we hold like.
Yes, my lords. This is the very same photograph. The very same photograph, my lords. I think it has come out.
Yeah, in my brother's copy, it is different.
Yes, my lords. There,
They have given something else to us also.
my lords, there, the electricity pole, if your lordships may kindly see, it has the electric pole in front of the building has been put towards in front of the divider. All other buildings are following one particular line. The electric line goes in a different direction because this building is obstructing. So this is the encroached area. And that is not. And lords, it is for the PWD officials and the city corporation now to state as to what is the current position, because it is their own documents which say that the road is measuring 120 feet and there is an encroachment. It is for them to take a stand, my lords, here. And it is their reports based on which I am before this honorable court. This is my contention. And it is their own building sanction plan, irrespective of the other documents. Their own building sanction plan says that the road area is measuring 120 feet. They have to at least abide by their building sanction plan. Therefore, my humble submission was let the government take a stand with respect to the width of the road here, because for all other buildings, there is one measurement given and they are following a particular measurement. And it is for this building, a different set of measurement is being proposed. Please.
Anybody else? Anybody else?
We have filed a statement of objections as early as on 8/7/2022. And at paragraph 6, we have specifically stated, my lord, based on the documents annexures R1 to R3, my lord, that they have encroached to an area of 2,051 square feet. This is based on the information given to us from the Davangere City Municipal Corporation.
So on 10th February,
Obligement.
on 10th February for orders.
Not only one thing.
Without-
My learned friend said government itself has said that, my lord, there is encroachment. Then I asked myself, how did, my lord, the government take the building, my lord, on lease for 15 long years?
Well,
And
of the moment we came to know.
Long years, my lord.
The
They were,
mo-
my lord, the building, my lord, was taken in 1996. For 15 long years, my lord, I have all the lease deeds, which I am willing to, my lord, produce. Generally, there is a lease deed, my lord. Give it here. These are the lease deeds, my lord. Noted? Office, my lord.
Keep it here.
My lord, while taking a property on lease deed, usually, my lord, at the time of conveyance, we do not see whether this is constructed, my lord, as per the sanction
PWD, my
plan.
lord, I mean, I
My
was
lord,
advocate general,
my
I
lord, the
noticed.
moment, maybe, but this is on the lighter side. The moment we came to know that it was encroached, immediately we vacated the
After 15 years,
premises.
my lord,
Yes, yes, the moment we came to know,
Immediately.
after 15 years, they vacated.
we vacated.
In fact,
Lighter side. my
before,
lord.
my lord, the government buildings are taken on lease. PWD, my lord, goes inspects only if it is, my lord, legal, then they take it on lease. I know it because, my lord, as the AG, I have dealt with this kind of.
My lord, this is based on the pleadings already there. I'm making my submission.
And I appear for the corporation, my lord. The reports and sketch in pursuance of the court order made, my lord. There is an encroachment indicated. My lord, I stand by that, the report.
And you are not doing anything.
No, two writ petitions are filed. Earlier, we issued notice, my lord, under 321, and they did not remove the encroachment. Then, my lord, 323 notice was given, two writ petitions they have filed. They are pending before this honorable court, my lord. And there is an encroachment, my lord, so as per the sketch prepared. The same one, my lord, which we had prepared, and it is in pari materia with this.
In petition we filed was, my lord, they increased the assessment. Against that we came, no, there was no, my lord, order, my lord, for demolition or 321 notice. I don't know where they get it
My
from.
lord, one more aspect. That's with respect to the no objection issued by the National Highway Authority of India. First of all, there is no provision under law and under which they can issue a no objection certificate. Secondly, my lords, that no objection was to put up a third floor. But whereas the question here is with respect to the encroachment of road area, that would not help the respond number 9 herein. Not in this regard, I have filed a synopsis. Not
Very good. Please. Which was the number 27. So for orders on 10 to.
Yes. 230 for withdrawal, seal number 84, contempt. Manjunath Rao.
File this application, memo for withdrawal of the contempt. The accused has reinstated the complaint into service bill.
$84. Memo dated 14/11/24, to which the attention of the court was invited by learned advocate for the complainant. Reads there then the court the memo. In view of the contents of the memo, permission to withdraw the petition is granted. Petition stands dismissed as withdrawn. Honored additional government advocate Srimati Prabodh has no objection to the withdrawal.
Seal number 85, Shiva Swami. Print, my lord. Pass over, my lord. Senior engaged in quota number 5, pass over.
Paso, senior is coming
Ah,
to withdraw the petition.
no.
Name? Why pass? What is pass over matter not to be kept at 2:30? 2:30 matters are touch and go.
Sorry.
You are here. What is, why 2:30?
Madam, the purchaser has challenged the order of the AC and DC only to an extent of 3 acres. The, the subject matter of the land matter at 6 acres and 16 guntas. The run sinkage is set aside.
That Nikanti.
Page 42, madam. Page 41, sorry, rare. Petition scheduled land, 3 acres, 5 guntas. The application to an extent of 6 acres, 16 guntas, which was the granted land. The respondent's case method only to an extent of 3 acres, 5 guntas.
Delay of 25 years.
There is.
Making the restoration application.
There is, but no matter, there is an amendment to section 5,
Petition is allowed because the authorities granted the restoration. Deputy Commissioner said,
Pardon me?
what survives except our order?
Now since there is an amendment to section 5, the constitutional validity has been called in question, that is pending.
Oh, that is.
But here, there is no occasion for me to challenge the order of the beyond jurisdiction in the sense, my lord. Their claim is only to an extent of 3 acres. The Lansing judges ought not to have quashed the entire order to an extent of 6 acres. Rashma kindly see the order passed with the AC at page 62 to an extent of 6 acres and odd, page 62.
Page?
Page 62. Order of the Assistant Commissioner, Annexure B, 6 acres. This is the granted land. The purchaser has questioned the order only to an extent of 3 acres, 5 guntas. The learned judge should have restricted, my lord, at least if it is to be allowed, only to an extent of 3 acres, 5 guntas, not to the entire order. Entire order of the AC and DC should not have been quashed.
5 acres and 20 acres.
Yes, my lord. Including Karabara, it comes to 6 acres.
Survey number 91.
Yes, my lord.
Where is it 5 acres?
As per Annex C and C1, my lord, the purchase has purchased, as per Annex C, my lord, he has purchased 1 acre at page 69. As per Annex C1, 20 guntas at page 83. Page 69, my lord.
See, the original allotee initially sold the entire property.
Yes, true. I am not denying the.
Thereafter, a
Yes.
portion was purchased by the
True.
present
So therefore, my lord,
petitioner.
whoever agreed to an extent of at present purchase, they should have challenged that. Now, my lord, the respondent herein has questioned only to an extent of 3 acres and odd. The order should have been confined only to an extent of what it has been challenged before the single judge.
No, you show the application for restoration was for how many? What is
6 acres, my lord. 6 acres. That
so
is,
then that is-
Rashmi kindly see, my lord. Page 57. 70, I ha- though I have sold in 1974 entire extent, my lord, subsequently the purchase has sold in favor of so many persons. My lord, the present the contestant respondent has questioned only to an extent of 3 acres and 3 kuntas. By the submission, my lord, the order of the learned single judge should have been restricted only to an extent of 3 acres, 3 kuntas. Because the other purchases are not before the Honorable Court.
For orders on 4th February. Without reserving it, not be notified. No argument on that day.
Number 86, so P. N. Anjareddy.
Respond number 5 in this.
In this case, there is no delay, my lord. There is no delay in restoration of the land. There is no delay in approaching the, not on the ground of delay, it was set aside. The grant was restored in favor of the petitioner, appellant. So that's not covered by the decision of the Honorable Court. It has to be heard, my lord.
So it was not a granted land.
Granted land, it is restored in my favor, and there is no delay in approaching the deputy commissioner, and it was restored in time. There is no delay in, the single judge also has not considered, not decide on the question of delay. Therefore, it has to be heard, your lordship. Kindly order notice.
How come the two sets are different?
Yeah, two sets are different. Filed by some other advocate.
Member, this check.
This is by Shobha Limited. Yeah, this is correct, sir. Actually, this is wrong. This is correct, this is wrong.
So we have some.
No, petitioner name is also
Not wrong.
That itself is wrong.
How come that number is same? No, 24 and 20. This is 24. This is 24.
Yes.
This is clear. That is all.
The petitioner name is Municipal.
61. So different papers of this one wrongly. Not no problem, but then it is available. There is no delay.
There is no delay. The land single judge also not decide on that issue.
When did you file the application for restoration?
My lord.
24.
2006 is the last sale deed. Then when did you file the application? Five, section 5 of the.
2012, my lord.
17/6/2012.
2012.
17/6/2012.
2012.
6 years. But the reasoning is this.
No, earlier it was restored.
Not say that by anybody. It will-
Earlier also it was, but that is not considered my land single judge, my lord, the question of. Only thing, my lord, the disputed fact, it has, we have to approach the civil court. That is not, my lord, the intent of the act. It has to be heard, you last may kindly have.
That person sells again in 1994. Thereafter it is restored. Two sale deeds are set aside and restored in the name of the grantee. Then the grantee gets it converted into residential purposes. And then he executes a GPA in favor of one person who then sells the property in 2004. This is the configuration that are one is the convention number. Others will land from the subject matter to the CH.
Until you can order.
It is among the other, in the front of this judgment. Right. Okay. And basically the people
Is correctly reasoned order, paragraph 6. And
Para 8 to last may kindly see.
it is not just delay or delay.
There is no delay.
The question is, the land was converted, therefore it ceased to be a granted land, and the question of 4(2) will not arise.
Not converted by the petitioner.
It is converted. Next, ref is the conversion order. Dated 29, ref 5 years. Dated 29/3/21. Sorry, appeal is dismissed.
Number 87.
Waiting for the appellant.
To Sudeep, please.
My lord, with respect to respondent number 5, steps, my lord, filing a memo, my lord, dispensation of permit me to file deceased respondent number 5, my lord.
39 years.
There's a delay, my lord, but my lord, before the authorities, my lord, the delay was not an issue, point in issue. My lord, the AC court granted, my lord, ex parte, respondents was placed ex parte and was granted. My lord, DC, my lord, he has rejected it on the ground that the lands was converted, so you cannot re-grant. My lord, that is factually incorrect.
What is,
Only,
what is factually incorrect?
my lord, the lands was not converted when it was sold. DC comes to the conclusion, based on this full bench judgment, that converted lands, my lord, it can be, without permission, it can be sold. My lord, this is a case where at the time of sale, the lands was not converted.
Maybe, but after 39 years, you are seeking restoration.
Yes, my lord, but that delay was not considered by the DC.
The learned single judge rightly considered. It was
The
on the
learned
face of
single
it.
judge, my lord.
It was on the face of it,
Yes, my lord, my lord, one of
Emerging
our,
from the
one
record.
of my
emerging from the facts.
learned single judge has taken up this issue and dismissed my appeal. My lord, Rashmi, kindly see
Deputy Commissioner allowed the application filed by number 1 to 4, set aside the order. Passes to Commissioner.
page, internal page 6 of the judgment, my lord. Internal page 6,
Original grant.
6th line, my lord.
Nothing,
My lord, internal page 6,
page
bottom 6th line, my lord.
Yes.
Respondent number 6, Deputy Commissioner, referring to the order passed by the authority converting it to utilize for commercial purposes, has placed reliance on the full bench judgment rendered by this court in case of so and so. My lord, and others is in this background, respondent number 6, Deputy Commissioner held that since the petition land is diverted, the same ceases to be granted land under the provisions of Zones Act. Placing reliance on the full judgment, respondent number 6 has allowed the appeal and set aside the order of resolution. My lord, now
On the ground of delay dismissed. Several orders have passed. Please vote at 21.
Number 88. L. Srinivas Babu.
For
the petition in this case, my lord.
There are 22 years in getting the
My lord.
land restored, in filing the application for restoration. I am the purchaser. With inordinate delay and lapses, and this matter is covered by lots of judgment.
Yes, my lord, there is a 39 years in delay, my lord.
So
1962 is the grant and first sale is that 1981, my lord. And subsequently, the petitioners are approached the authorities during the year 2001, 2002, my lord. There is a 39 years delay, my lord. But in this case, there is a fraud, my lord. On the
Rightly
basis of
dismissed.
fraud, the sale was executed, my lord.
rightly dismissed.
Lots of judgment,
Yes, madam, dismissed.
So number 89. Mr. Ramesh Kumar RV.
Okay, grant him.
Serial number? Yes, up 230. Yes. OBD continue. Also 42 years. Who are you? Legal heirs of the original grantee.
Granted.
Unfortunately, many have argued, so you need not argue.
Yes.
Dismissed.
So number 90. Mr. Maruti GB.
For appellants, my lord. My lords, there is an
What is 95?
but I is filed for condemnation of delay, my lord. There is 644 days of delay, my lord.
17 years.
That is for
Application filed by the number 3 before. So Deputy Commissioner did what? Dismissed or allowed?
my lords. That's as the appellant is illiterate, my lord, she couldn't approach the advocate, my lord.
So you are purchaser?
Yes, my lord,
No, you are grantee.
yes, my lord.
Same. Granted to.
Granted to the father of the appellant, my lord.
Father of third respondent. You are purchaser.
No, my
Who
lord.
are you? Allowed. No,
Grantor.
you are
Granted.
purchaser. No, petitioner was purchaser. You are Jamaya. Correct? Yes. So dismissed.
That's. My lords, before. But before that, in Assistant Commissioner, before DC, the order has been made in favor of appellant itself, my lords. So one chance may be given to the appellant, my lords.
No chance. We are not here to give chances.
No, my lord.
Nor we are taking chances.
No, my lords.
Yes, sir.
So number 28.
My lordship, my lordship, in this I am appearing for the impleading applicant, my lordship.
This is PAL.
PIL, my lord. My lord, the short question for consideration in this PIL, my lord.
My lordship, a weak accommodation may be granted for.
My lords, this matter was actually heard by my lords, and my lords had indicated that that you would dispose it on the next date. They are in.
Please remind us.
Please, please, my lords. My lords, the annexure A at page number 24 is the layout plan, my lord.
But we are new here to argue. Madam.
Please, my lords. My lords, this, I'm challenging the allotment of civic amenity sites which are earmarked for specific purpose to the respondents, my lord. Annexure A, if my lords were to see, there are 3 sites above park, my lord, at page number 24.
We'll go through. No to remember. Keep it on 6th of February.
Obliged. My lord, same stage, my lord, because the impleading applicants have kept some obliged.
So 29 is urgent. So number 30. Mr. Pradeep HS.
Respond.
I represent respondent number 11 in this case, my lord.
Your lordship, we are challenging the encroachment made by the respondent number 11 on the Raja Kalwe. a drainage which is situated in the Schedule A property.
My lord,
The
I require a
respondent-
short accommodation to file my objections from this, my lord.
The respondent number 11 has furnished the false document and obtained the plan to construct the huge apartment reflected in the page number 125, your lordship, that is annexure P. The resolution passed by the Kanakpura Planning Authority, that is respondent number 5 and 6.
Encroachment in the lakes and graveyard
And catchment area.
catchment. Where it is there? Is at what place?
Your lordship kindly see that is in the
Learned advocate Miss so and so appearing through video conferencing, correspondent 1/11 wants to file last hand over to 18th March.
My lord, respondent 5 is concerned, my lord, I have filed wakalat, my lord, my name may be shown.
Learned advocate Miss so and so states that though wakalatama is filed by him, name is not indicated.
Please.
While noting full stop, while notifying the petition, his name shall be mentioned by the registry. Next.
Please.
Number 31. Srimati B. Vidulata.
In this matter, by previous order in the year 2019, my lord, the petitioners were permitted to remove the stones, my lord, from their agricultural land by an order of this honorable court, my lords.
Probably you are to take instructions.
My lord, may I make one submission? My lord, if they file, my lord, in one petition, my lord, in the first petition, they have filed a representation, my lord, that is at annexure. My lord, page 64, annexure N, dated 21/3/2023. My lord, that I have instructions to submit that it will be considered, my lord, within a period of 2 weeks is what they say. If my lord could grant us 4 weeks' time, my lord, the representation will be considered in accordance with law.
My lords, it's not the consideration of a representation, my lords. There was a positive direction, my lords, issued by this honorable court. Kindly, my lords, page 42. The relevant portion, my lords, is at page 44. Lords, the directions, my lords, your lordship's got page 44, my lords, para 4. May I read para 4, my lords? In the last 3 lines, in the circumstances, we direct respondent numbers 3 and 4 to consider petitioner's request and grant mineral dispatch permit to facilitate her to remove stones from the aforesaid survey number within 8 weeks from the date of receipt of the order. My lords, at this point of time, it was allowed. Thereafter, my lords, the minor mineral concession rules is amended. Now, the word minor mineral is deleted from the rules. That's why they say now we cannot give. Our representation is not subsequent to the amendment of the rules, my lords. This direction was there when the rules provided for it, my lords.
My lord, may I make one submission? My lord, may I make one submission? My lord, here there is a dispute, my lord, between the petitioner and her daughter. That is one, leaving that apart. My lord, secondly, my lord, since a positive direction, my lord, rightly or wrongly, has been issued. My lord, if that had not been implemented, then it was open for the petitioner to file a contempt. My lord, that apart, my lord, the building stone here, my lord, here there is ornamental mineral also, along with the building stone. It is for that reason, my lord, I had said that we will consider the application in accordance with law, because they say 20% of the land, there is ornamental mineral, my lord, the officials will decide as to how to go about, my lord, with regard to that. Building stone, my lord, maybe the officials will not have, my lord, any objections.
My lords, the difference between mineral ornamental stone and building stone, my lords, is just the size. The same granite, my lords, if it is in a larger extent of land, it will be an ornamental stone. While removing, if it is broken into small pieces here, my lords, there is no question of removing it with ornamental stones because we need machinery from Germany and we need huge machinery, my lords, if it has to be removed in big blocks. These are very small farmers. Your lordships may see there hardly 1 acre of land, my lords. They can't bring in machinery from and if we remove ornamental stone, my lords, it is the state which will benefit from it because we will pay royalty accordingly. And here it's not possible, my lords. It's humanly impossible for a small farmer to remove huge stones from the earth. What he will do, kindly see the photographs, my lords. If your lordships could see the photographs of what stones are there, I don't know, my lords. Kindly see page 21, my lords, is the photograph. 21, 22.
Reply, I will find. My lord,
We will just remove, my lords. I don't know why reply and all this. My lords, the only question for consideration of this honorable court. My lords, these are all small time farmers. That's all, my lords. Where is ornamental stone, my lords, there? They will use it for agriculture. Removing those stones, they'll fill it with mud, use it for agriculture.
If they reply on all these, we'll say reply.
My lords,
no, my lord.
Madam files reply, my lords, I will not be able to do this. From 2017, I've been asking. I'll use it for agriculture, my lords. I won't be.
Something more than what seems.
Nothing, my lords. There is nothing.
Lord, I wanted to have it resolved, but since my learned friend is objecting.
No,
very
I'm not
well.
objecting.
And this looks like a Karab land also.
Yes, my lords.
Obviously, it can't be agricultural land. It is a Karab
No,
land.
my lords. No, it is 20% is this stone.
It's B Karab and your possession. It's not government Karab.
Yes, my lords.
Yes, that's it.
My lords.
It's Karab land basically as of now. It's not an arable land.
It is as of
How
now.
can this be? How can this
Kindly see the
water body, the stones can be arable lands?
Kindly see the report, my lords. There is a report also in this
The
regard.
remaining portion, where is the RTC? RTC will establish it.
RTC, my lords, I have it at.
Yes, 26 guntas is
page
Karab land. After
yes.
of 2 acres, 17 guntas.
17 guntas.
B Karab is 26.4
26
guntas. That's it.
But out of this, we have 20%, my lords, could be, if it is removed.
A Karab is government, right? B Karab is private.
Yes, ma'am. We just have to remove this.
This is the total extent. That is 2 acres, 17.4 guntas.
See, if you go to a head,
Out of which
this is what.
26.04 is B. B Karab means it is 1 gunta. A Karab means it is 1 gunta. Where there is water body or rock. So the photographs also proves it.
They are conducting agriculture.
Make it durable and it becomes taxable. That is for land assessment. And it can be made into agriculture. The subject matter is the petitioner's intention to utilize this particular piece of property for a person. But okay, this belongs to the it is for them to take a decision, but they have to take a decision mostly.
I wanted to avoid all this, my lord.
Kindly
but my
see
lord
page-
may grant me some time.
It's just that, my lords, they don't have the resources to come again and again. That's all, my lords. Kindly see page 31, my lords. This was the report.
But you are bound by the earlier judgment, 56269 of 2018.
My lord, that, yes, my lord, the positive direction couldn't have been issued.
Kindly see, my lords, page 32. It is
There is
1010
no contempt.
square meters of ornamental stones and
Very
remaining
fine, there are
90%
contempt
is,
proceedings. My lord,
but if I
please.
file contempt, they will give endorsement, they'll say go back. If I don't say file contempt, wait for some time, they'll say file contempt.
Now, how could a
Page
positive
31
direction-
and 32, my lords, there is an exact quantity for which they have to issue
We direct respondent number 3 and 4 to consider petitioner's request and grant mineral.
mineral
And
dispatch.
is wrongly timed to grant.
No, my lords, no, my lord. They were heard.
My lord, I'll place the entire this thing before my lord. My lord can pass any orders.
At page 32, there is a
I'll
clear,
file my statement. I'll place it before my lord. Statement I will file and I'll place it before my lord and I'll leave it to my lord.
can I request an early date, my lords? 2017,
Lord,
we have been
this
asked. My lords, royalty will,
Short adjournments. My officers don't respond.
my lords, for my learned friend, it is the officers. For me, it is the agricultural land. I'll be paying royalty. They won't lose anything. If
Doesn't
they,
appear to be agriculture.
they won't lose anything. The state won't lose anything.
You file it. When you will file?
No, I'll file. My lord may grant me some time, I'll file.
6th of February. Little
Too
long.
many matters on 6th. my lord.
This is a simple matter for my
That's
friend, my
it,
lords.
So some more time, my lord.
My lords, I
long.
18th or 19th,
filed this only in July,
14th February.
oblige.
14th February. I hope she comes with a nice thing, my lords, on 14th February. Grateful. The second matter was also the same, my lords, the other matter.
Seal number,
Third matter. Same date, could it be listed?
seal number 32. To Manjunath J. Secretary.
My lordship. Appear for appellant. Appearing for appellant, my lordship. 3 applications have been filed. Respondent number 4 has read.
Nikanti.
Yes, my lord.
That may I make a
By the
submission?
purchaser.
That she is my vendor, my lord, and
Orders are set aside. Set aside.
that there is a 15 years delay for the purchaser. And
Orders
the-
are set aside. Petition is allowed on the ground of what? Fifteen years.
Yes, madam. That so far the steps are concerned for respondent number 4. She remained, she has not participated in the proceeding before the learned single judge. And moreover, my lord, she is my vendor. First sale is to her in the year 1991. I purchased in the year 1999. Application is filed in the year 2005 and 6, my lord.
Yes, madam. Come with the better matter. Dismissed.
Please.
Seal number 33.
Lord, I had moved an application for advancement. Lord, the urgency in this matter, I'll just mention a couple of facts. Lord, I am for the respondent. The respondent is MRPL, which is a central public sector enterprise under the Ministry of Petroleum. Lord, we have a unit in Mangalore where it's called as an aromatic complex, where we produce some aromatic hydrocarbons like paraxylene, benzene. We wanted to produce another aromatic hydrocarbon called toluene. India imports about 650,000 metric tons each year. That is the requirement, but we produce only 160 TMT. So if our unit goes up and running, we will produce about 40 TMT. So that's the saving on the import exchequer. So for that, my lord, we had to improve our electrical systems. So from 33 kV, we wanted to extend it to 110 kV. For that, we called for a contract in May 2023. The appellant was successful and the contract was awarded to the appellant. In 9 months, the appellant had to complete the contract. The appellant could not complete it within 9 months. We gave 3 extensions, which ran up to about 4 months. So despite lapse of 13 months, he was unable to do it. So once the contract lapsed, then we formally communicated that the contract stands terminated. Now that termination has been challenged in a writ petition. Please have a look at the prayers in the writ petition, my lord, which your lordships will see at page 47. Page 47 is where the prayer in the writ petition can be found. Firstly, issue a writ of certiorari directing or order quashing the termination notice.
Tender contract.
Yes, tender contract. My lord, then declare that the termination is so and so. Lord, in this case, what has happened is, it's a concluded contract. It was for 9 months. The 9 months period has already lapsed. Actually, it is the termination is a wrong term which may have innocently used. It's an expired contract. 9 months is over. We granted 3 extensions. It is over. Now,
Contract is terminated by the petitioner.
no, by me.
By-
Because I'm the one who awarded it. By termination, I only meant that you are unable to complete and it has lapsed. That is what I meant. Now, please have a look at what the learned single judge, Lord, he gives a detailed reasoned order. Lord, if your lordship would please take up the impugned order.
My lords, if I may be permitted to mention, yesterday they moved the matter only for listing of.
No, only I am impressing on the urgency. That's all. For the urgency purpose, I am reading out. In the impugned order, my lord, please have a look at
It was filed with a memo, my lords.
at para 21. Please have a look at para 21. Lord, page number 9.
It was filed with a memo on 24/12.
It was separately filed because it was not produced along with the main appeal.
24/12. 24/12.
Order is separately.
Lord, it's an order dated 18th December 2024
Yes.
in WP 26754 of 24. If your lordship got it, please have a look at para 21, where the learned single judge has extracted a few relevant clauses. 21, he says, as per clause 9.0, the general conditions of the contract provides arbitration and conciliation and states that in the event of any dispute arising out of the contract, the matter shall be referred to conciliator or arbitrator. Then, my lord, would your lordship straight away head to para 28 at page 13. Para 28, page 13. And learned single judge says, upon consideration of the aforementioned facts and the material on record, it appears that the matter at hand involves a complex question of fact as to whether unfavorable climatic conditions prevented servicing the tender works, or whether there exists an alternate approach road, or whether the concept of approach road is part of the scope of tender work, and the construction of the same being subjected to a detailed investigation and examination of witnesses and analysis of evidence. Furthermore, this court cannot sit in judgment on the issue of relevance of the contractual milestones or whether non-performance thereof could be attributed to the petitioner or the respondent. Admittedly, the petitioner has been suffering a negative cash flow since the commencement of the tender works owing to several reasons, including procedural delays in availment of loans and in receipt of payment from other projects. However, the fact remains that financial incapacity has restricted the petitioners from material procurement, and consequently, fund disbursement towards the attaining the contractual milestones has not been made periodically. Furthermore, respondents contend that no performance has taken place on the work site since June 24. Additionally, petitioner has produced a detailed affidavit along with the layout plans, drawing, and site photograph in support of his contention, the merits of which can be established only in a trial. Respondent number 1 has filed an affidavit rebutting and disputing the contentions of the petitioner. Therefore, such disputed questions of fact cannot be ordinarily entertained by this court in judicial review. Furthermore, a conjoint reading of the terms of the contract governing construction execution plan and clause 9 of the GCC reveals that the dispute at hand is the express subject matter of the contract, and any dispute arising from the terms of contract is to be referred to conciliation or arbitration. Then in para 31, my lord, learned single judge refers to why Supreme Court says one High Court should not entertain when there is arbitration clause. Para 31, in case of Titagar, the apex court had opined that where the substance of the dispute raised as regards to the competency of the respondent board to levy a coal surcharge was subject of an arbitration agreement, merits of such contention could only be decided in arbitration as per the contract agreement. The same has been consistently reiterated by the courts in so-and-so judgments. Then finally, my lord, para 35, the last page. Thus, this court had set aside the termination contract where non-performance was unmistakably attributable to the failure to discharge the contractual obligation and non-feasance on the part of respondent capital. However, in the case at hand, a perusal of the multiple correspondence between the petitioner and respondent does not at this stage fully attribute the reasons for non-performance of the party. In view of the fact that the case at hand involves complex question of fact necessitating appreciation of evidence and examination of witness, this court cannot exercise its rich jurisdiction in disputed questions of fact. Accordingly, instant petition stands dismissed and liberty is reserved with the petitioner to agitate the merits of all contentions raised herein before the appropriate forum. Now, my lord, when the writ petition was pending, when this learned single judge refused interim order, during the October vacation, the vacation bench had granted some interim order, and that interim order was continued even, my lord, before your lordships had said, though there is no merit in the appeal, interim arrangement shall continue because appeal was not, writ petition was not heard on merits. Now that the writ petition was heard on merits and the single judge has categorically held that it involves disputed questions of fact, my lord, the very writ appeal itself, there are no perversity or patent illegality or jurisdictional error that the learned single judge has committed. So therefore, my lord, the writ appeal itself is not maintainable. Now, please have a look at the interim order passed during the vacation, during the winter vacation.
No precipitative text.
No, my lord, now the learned single judge has stayed us from calling for further tenders. My lord, after the writ petition was dismissed, we placed contract on certain vendors. They have already supplied the material.
But then today your application number 1 of 25.
Yes, yes,
Preponement.
yes.
Please, my,
So when shall we list it?
any date, my lords.
Lord, for us, what has happened is, my lord, now my lord, my respective petition appellant can sue us for damages, specific performance. All these options I am not coming in the way. I am saying, why should my lord, I am capable of generating 40 TMT of tolling, which is in national interest. We are burning a hell lot of foreign exchange in buying TM.
29, please, my lords.
Full stop. IA number 25 of 1 of 25. Heard learned additional Solicitor General Mr. Kamath for the applicant and learned advocate Miss
Ashwini, my lords. Ashwini.
Ashwini Nagananda.
N. Ravindra, my lords.
Miss Ashwini for the respondent original appellant. For respondent original petitioner. In the facts of the case, the application allowed by directing that the writ appeal number 1877/24 shall be listed for admission hearing on 29th of January.
I'm grateful.
My lords,
I'm
can I
grateful.
seek extension of interim order, my lords, until next date of hearing?
Is limited.
Limited, my lords.
The interim order granted earlier shall continue to operate till the next date.
Much obliged, my lord.
I'm grateful. No, it'll come in the admission list. It'll reach earlier. It'll reach earlier. Grateful.
34.
Yeah, for the petitioners in this matter.
Okay, for respondent number 5 and 6, ma'am. The last occasion,
That's me.
there was a direction to the state. What's happened on 1956, whether they acted upon the gift deed or not? And to produce the mutation with the effect of gift deed.
Is a public interest litigation, my lords, wherein the petitioners are the villagers, my lords. In the year 1956 itself, my lords, one Pattabhi Ramarao, he will give the property to the government for an extent of 1 acre 35 guntas in order to establish a school. That is on 26/5/1956, my lords. After the execution of the registered gift deed, my lords, the EC has been reflected with the government's name and the RTCs also, my lords, has been reflected. Now, my lords, among the said 1 acre 35 guntas, our allegation is that, my lords, respondent number 5 and 6.
Declaration and possession, and on the basis of that, they are seeking possession of a playground, my lord, which is used by the children of the primary school. And that was
Respondent number 5 and 6, ma'am. Respondent number 5 and 6. Now, my contention is that the petitioner suppressed the earlier proceedings, though he has the witness in this earlier OS suit, and he deposed that the land not belongs to the government. After,
What is your stand?
not sale.
Who?
Annexure E of my petition, my lords, is the sale deed produced. Annexure E. Page number 50, my lords, the typed copy, the translated copy is at my lords, page number 57.
We'll take up. Today is what date? 23rd will take. 23rd. It was heard, no, to some.
Yes, my lords, please, my lords.
23rd.
Please.
Please.
Thirty-five, 36 are urgent. Seal number 37.
In this matter, we have filed our compliance affidavit.
Nobody is there.
Monica Juliet.
4th February. Compliance. 4th February.
Number 38. SB Mukanappa.
Complainant in this case. Accused number 2 has not complied the order.
Let's, in view of the single bench order, I am ready to comply the order which has been passed by the single judge. We are not contest the matter before the single judge, and then there was an observation has been made by to in order to pay the payment of 25,000 I am ready to pay.
No, my lord. My lord, the 6 months, 17 months salary has to be paid by the management accused. And as well as the 25,000 rupees cost to be paid to the complainant. Kindly once see the page number 30, that is annexure B, my lord. The page number 30, my lord. The respondent number 4, which has been served and has remained unrepresented, is directed to reinstate the petition forthwith. Respondent number 4 is also directed to draw the salary of the petitioner and make over the same to the petitioner within a period of 2 weeks from the date of receipt of copy of this order. Since the petitioner has been forced to legislate for this last 6 months and the management has decided to disobey the order of DDPI to reinstate the petitioner, it would be appropriate to impose the cost of 25,000 rupees payable to the petitioner within a period of 2 weeks.
You are reinstated.
No, he is reinstated, my lord. On 26/12/2023, pursuant to the order passed by the Honorable Single Judgment, only in relates to the payment of arrears of the salary and as well as the 25,000 rupees cost to be payable to the complainant. Even though, my lord, they have not appeared before the Honorable Learned Single Judge also.
So only cost part remains. Only payment of cost remains.
Payment of cost and as well as the arrears of the salary, my lord. And from September 2022 to 26/12/2023, they have to be paid, my lord, salary. That is the observation made by the Honorable Learned Single Judge, my lord.
Direction.
After suspension, my lord.
In view of the observation has been made by the learned single judges in para number 6 minutes. Insofar as that is concerned, I am ready to pay 25,000, whatever the fine amount which has been paid by. And insofar as the direction which has been made by the learned single judge, anyway, the respond number 2 has been remain unrepresented before the single judge minutes. And more so, now in view of the order passed by the single judge minutes, he reinstated the service and on 26/12/2023 onwards minutes. Now from the date of reinstated the service minutes, he has regularly obtaining the minutes, whatever the benefits and the salary as well as the minutes.
Para number 5.
Para number 6.
Kindly read the para number 5 also.
I did it.
Sorry.
So pay the salary.
Regular minutes reinstate from the date of.
You are appearing for number 2.
No minutes. I am representing on behalf of the
Accused
respondent
number 2 is the accused number 2, my lord. In the petition respondent number 4, here, my lord, the accused number 2, my lord.
So he is the employer.
The management, I am the employee of I am the teacher.
He is the employer.
Yes, my employer, the management of the school. Even the honorable single judge has sent the notice through the police department. They have not appeared before the honorable single judge, my lord. That is the disobey of the order.
Regard for the department.
Please, my lords.
Initiate the action against them if he is not.
Lords, that is what we have done, my lords. The direction is there in 7 and we have filed the affidavit. We have taken action against the management, my lords. We have recommended for withdrawal of
Even the-
grant-in aid and also, my lords, issued notice.
But then it will not resolve or absolve from complying with the direction. You are number 4 now.
Respond number
Number
2.
4 be Sri Lakshmi.
Here, my lord,
Accused
accused number 2.
management.
Yeah, Samaste.
Samasthe.
Samaste. Lakshmi Narasimha Vidya Samaste.
Lakshmi Narasimha Vidya Samasthe.
So what is the amount of salary payable?
But half of salary more than, my lord, more than 60,000 rupees salary per month. Even other half of salary in the result.
There was allegation has been made against him. Lords. Due to that account, my lords, he was suspended from the services.
Suspension.
There was. The allegation has been proved. The charge sheet has been filed. The matter has been seized before the.
Judge. Goes against respond number 4. Who was the management from employer required to reinstate the petitioner forthwith. It was further directed that respond 4 shall draw the salary for the petitioner within stipulated time. Cost was imposed to be payable to the petitioner to the extent of 25,000. Full stop. When the contempt petition comes up for consideration, it is stated that though the petition is reinstated, the rest of the part of the directions are not complied with. Full stop. Respond number 4 is respond number 2. Original respond 4, respond 2 herein.
Respond number 2 in the contempt petition.
The secretary.
Secretary.
Is directed to remain personally present before the court on 28th
Minutes,
of
I'll take minutes, I'll
January.
take instruction and I'll file a statement of objection at least minutes, a reply minutes.
If the
And
amount
I'm
of-
ready to minutes, the complaint, whatever the order has been passed.
If the
Insofar
amount
as
of-
minutes,
if the
payment
amount-
of 25,000, whatever the.
The amount of salary and amount of cost is paid.
Yes.
From the personal presence shall stand dispense with. Personal presence of respondent 4 shall stand dispense with.
That's one submission minutes.
If the directions are not complied with and the salary and the cost is not paid, the court is bound to take a serious view.
That's one submission minutes. I'm ready to pay minutes, whatever the observation has been made by a single judge. And also minutes, insofar as minutes, the
Yeah.
termination.
At the end of the argument, at the end of the order, you are bringing out the check.
Anyway, minutes, I'll,
Don't want to pay.
I'm ready to pay minutes 26 minutes, para number 6 of the observation,
So you're paying-
25,000, whatever the fine amount minutes. Fine amount minutes, I'm ready to hand it over the
It's
check.
25,000.
25,000 is there.
When you will pay the salary?
So I'll check out minutes from the minutes. In fact, minutes, he was not represented before the trial court minutes, before the single bench minutes. He had no knowledge. Anyway, minutes, the order has been passed by the single judge
We are
minutes.
not about the-
Have not
we are-
appeared before the honorable single judge.
Are you paying the cost or still you are not willing to pay?
I'll check.
Hand
I'll
over-
come to him.
Hand over the check.
Welcome.
Hand over the check to the council.
The-
Right. Struck up that order. First part is all right. The only part of remains is the payment of, only part of compliance remains is payment of cost and salary to the petitioner complainant hearing. Full stop. In course of the hearing today, learned advocate Mr. So-and-so with the respondent number 4 stated that he has brought check received from the respondent 4 of rupees 25,000.
25,000.
25,000.
Which check is handed over to the counsel of petitioner towards satisfaction of the cost of 25,000. First of the check number so-and-so, dated so-and-so, drawn on so-and-so bank, is received by the counsel for the petitioner on behalf of the petitioner. Full stop. The salary shall be paid when?
I'll just, my lord, salary was not, my lord, it is only meant for, my lord, there was allegation is been against the, proved against the, my lord, the petitioner. And when I'll take instruction from, my
When
lord,
the
section number
counsel,
2.
the respondent number 4 was asked.
I'll
as
just
to
check
when
out.
the amount of
Weeks time.
salary will be paid in compliance of the order of the court, comma. There was no, the council was not able to answer.
No, my lord, I'll complain, my lord.
What you are answering? Within what time?
That's week's time may be granted, my lord, I'll check.
Times. He fairly stated that within 1 week, the amount of salary shall be paid.
The second respondent has to pay, my lord, in this case, my
Full
lord.
stop. So
Government employee.
as per the statement, the petition, contempt petition shall be listed next on 4th of February. If the amount of salary is not paid. And
Then-
before that date, comma, court will take a stern view.
I'll complain, my lord. I'll take instruction and I'll complain. I'll take instructions and I'll
No
complain.
instructions. We want another check. Another check to us.
In fact, my lord, that has to be done by the respondent number 2, my lord. The respondent number 4 is the management, my lord. It's a private entity, my lord. It's the only benefit of.
Even the recommended by the respondent number 2, they have not complied the.
Our rules very clearly state in case of suspension or dismissal, it is the private management which has to pay
We
the
do
salary.
not know anything. We know the black and white of the order. Okay, when we are in contempt, we do not know anything. We do not know any merit of the matter, except what is stated in black and white. So if you are not willing, then you may come.
Week's time may be granted.
To be listed at 2:30. Yes, next.
Mr. Naveen Jain.
No.
Number 39, Mr.
11th
Naveen Jain.
11th February.
Number 40. Mr. Nandya Reddy PN.
Day after tomorrow, my lord. Senior,
Day after tomorrow. Why?
senior counsel.
So, we'll argue on your behalf. Yes, what is the matter?
Not well today, is that?
Hmm?
He's not well. I am also not well. Day after tomorrow, or Monday, your lordship.
But we will argue on your behalf. Who will appear?
That's government.
Only the direction of the tribunal is to consider the representation.
Yes, we have
for promo-
considered.
That is confirmed by Learned Single.
No, that is promotion to the post of deputy superintendent of police was not considered. You are page 28, Lord. Para 6. There was a review petition. Annexure C, page 28, your lordship. Case of the petitioner for promotion to the cadre of deputy superintendent of police.
And your senior will come.
Day after tomorrow.
Day after tomorrow. So we realize that you really need a senior, if at all we are convinced. Day after tomorrow is 23rd,
23rd.
to be listed at 2:30.
Right.
Upon request of learned advocate Mr. Nanja, that the senior counsel will conduct the matter on that day.
Number 41,
Yes.
so Virupaksha appears.
That's order of the learned single judge, my lords, is at page 23, my lord. The petitioners had filed applications, my lord, for redetermination of compensation, my lords, payable in favor of the petitioners. My lords, during the pendency of the contempt petition, my lords, the respondent authority, my lords, in fact, has passed an order, my lords, redetermining the
We have
compensation.
complied the orders.
However, my lords, on the last occasion, I had made the submission. The compensation, my lords, it is redetermined, my lords, in the month of June 2024. However, my lords, till today, my lords, in terms of the order, my lords, the compensation has not been dispersed in favor of the petitioners. On the last occasion, lordship had directed them to take instructions, my lord, why the compensation amount is not
Lords, may
paid.
kindly see paragraph 3 and 4. Lords, we are ready to release. There are many complainants who have passed away. Their legal aids have not come forward. They have not produced their documents, my lords. In case they produce the documents, we will release it immediately. Your lordship may kindly see paragraph 4. 3 also. We have issued notices, my lords, several notices
Which paragraph? Of your
of
compliance?
the compliance report, my lords.
Then you are supposed to consider an application, that's all.
We have already passed an award, my lords, of the compensation. To release it, my lords, they have to come forward and produce the documents because they have passed away. The beneficiaries have passed away, my lords. The legal heir should produce the documents and get the compensation.
You are referring to page 14?
Page 2 of the compliance affidavit, my lords.
Two of the complaint.
Paragraph 3 and 4, my lords.
No. Notices, one of the notices, page 14. So to consider the application.
My lords,
Consider. And you are asked for to submit the documents. You are not
my lords,
able to
my lords, we have submitted the documents on 8/7.
submit to them, not.
My lords,
to-
it is submitted to the respondent authority, my lords, on 8/7, my lords, I have the acknowledgements. After this, my lord, lordship on the last occasion had directed them to take instructions. What was done, my lords, on this, on the documents which was submitted by the petitioners?
Yes.
On 8/7, my lords, we have submitted all the.
Take instructions, my lords. As on the day the affidavit was filed, they hadn't produced the documents.
So then you
They-
pass over. the
My lords, it
document.
is given, my lords, to the, I will serve a copy, my lords, to my learned friend, my lord.
So unless you pass over the document, I'll be the first to forget.
My lords,
Then the council will forget.
my lords, I will,
Then my learned brother will. So at least you do it whatever, don't keep it to your file.
my lords, in fact, these documents were submitted to the authority, my lords. I will also give a copy, my lords, to my learned friend.
So that.
Lordship may have it anytime next week, my lord, by then,
4th of February at 2:30.
I am grateful.
So 42 is adjourned. 43. So we, Akshay Kumar Jain.
Yes.
Appear for the complainants in this, my lords. This is a contempt petition against the DC and Tehsil for non-compliance of the attachment orders of RERA, my lords.
Recovery to be initiated by the Deputy Commissioner, my lords. My lords, one affidavit has been filed. They have made Bangalore North Tashildar as the party. Lords, the search was conducted. There are no properties available in Bangalore North. Lords, we had requested them to implead Devnali Tashildar because some properties were identified there, so that we can file our status report and compliance affidavit, my lords.
My lords, if I may make a submission, my lords, the affidavit filed by the Tehsildar is false on the face of it because we did some search and they have movable properties. They've given affidavit stating that there's no immovable and movable property located in Bangalore. They are still operating out of the very same office, which is these. There are several assets worth lakhs in that said property, my lords.
But what is the direction?
Direction was so as after the RRC was issued in the RERA order, there a revenue recovery certificate was issued, directing the Tehsildar to recover, attach the properties, movable or immovable properties of the accused number 3, which has not been done so till date. And my lords, till date, this is just not a problem with respondent accused number 3, but overall till date in the state of Karnataka, 700 crores is due to the home buyers because of inaction of the DC as well as the Tehsildar.
Where is the direction to Tehsildar?
May I just make one submission, my lord? My lord, there is a stalemate situation in this matter. My lord, what has happened is, my lord, there is an order of recovery, my lord, against, my lord, this builder. But, my lord, the coordinate benches of this honorable court in 3 writ petitions, my lord, which was filed challenging the revenue recovery process initiated by the state pursuant to the RERA orders, there have been directions to the RERA authorities and to the revenue recovery authorities that they have to hear the builder before passing such orders, and my lord, that process is still pending. My lord, my second submission is the secured creditor, my lord, there are financial institutions who have funded these projects and all these properties. They came before this honorable court, my lord, in a writ petition. In their writ petition, my lord, there is an order passed by a coordinate bench of this honorable court not to proceed against the secured assets. My lord, this is submission number 2. There's a third submission, my lord.
Where is the coordinate bench order?
My lord, I will place it, my lord. They have not placed it, my lord. I kindly, my lord, grant me a week's time, my lord. I'll place all the orders of the honorable courts.
All right, come on.
My lords,
Which date?
those water submissions are not relevant to this present case because this has not been challenged, my lords.
It
The
has been
RERA
challenged, my
the
lord. I'll be
RERA,
able
my
to place
lords,
the
this
details
particular
along with an
case,
affidavit.
WP number 1569, it has not been challenged, my lords. And it comes, this contempt petition comes out of the non-compliance of WP number 1569 2024, which is available at annexure
3rd February.
A.
Number 44, the Keshav Murthy B.
Nobody is there.
This case we have filed our compliance affidavit.
Decision is taken.
Please, madam. This
To
is-
be listed at 2:30 on 5th of February. In view that the press decision is taken by the state government as per the statement made by Learned Additional Government Education Education, in compliance of the directions of Learned Single Judge.
Number 45, the P N Anjareddy.
My lord, I am appearing for accused, my lord. My lord, compliance is done. My lord, compliance affidavits are ready, my lord. May I be permitted to file the same, my lord, in the office? My lord? I'm sorry, my lord, due to some reason I'm outside my appeal. It is complied. My lord.
3rd February, complied.
A week's
Complied
time,
with
my
what?
lord, I will file the same.
6th of February.
Number 46.
Please, ma'am.
Sir,
This case, your lordship,
Keshwini.
I appear for complaint. The vehicle was repossessed, your lordship, the vehicle was seized. And now the vehicle has been repossessed by the third party. The vehicle was sold in by the bank in a public auction. And now the vehicle has been repossessed. And now we have to get the transfer of the vehicle in the name of the earlier party. And thereafter we'll do.
My lords may kindly see last order of last.
4 weeks time. It was identified recently. Your lordship, here, because of the communication by the.
You have withdrawn the.
Yes. Because of the wrong communication, we have seized the vehicle and it was, property was put for auction and now the vehicle has been found out and we have to, we have repossessed the vehicle.
Undertaken to withdraw. They had undertaken to withdraw. Till now, no steps has been taken.
No, we have repossessed the
And
vehicle.
they asked for this date. They said within 1 month, they will withdraw everything and give the vehicle back. Till
Now
today, they have not taken any steps.
We have repossessed the vehicle. We got the vehicle now because it was sold in a public auction. Now we repossess the vehicle and 2 weeks time may be granted for me to hand over the vehicle. Because now the.
If you are not abiding by your statement, let the bank manager be here.
Your lordship.
You are a bank?
Yes, sir.
Let him be here.
Your lordship, week time, your lordship, I'm
For
not.
what you are making statement then, Mr. Counsel?
Yes, your
For the
lordship.
making of
Your lordship,
statement?
your lordship, what happened?
Paper
The
statement.
vehicle was in the third.
You do not know, you withdraw all actions as per your statement.
Your lordship, a week.
Last time we saw that all actions you take in breach of the court's order.
Yes, Your Lordship, what happened? The vehicle was sold in a public auction, and
Yeah.
it was in the third party.
Yes.
And we have called upon that party to, we have.
Whatever you do, we
Yes.
don't know. Whatever
Monday,
mechanism you-
Monday it may be called. Monday.
Monday, what will you do?
I'll submit that the vehicle will be handled.
Will give vehicle to the petition.
Yes, yes.
So you are available.
Well, vehicle is available. Right now, vehicle is available.
Give it.
Yes, Your Lord, Monday I will submit.
And what are the other actions taken?
They have not. There is
You
one,
last time showed it.
there is one notice, my lord.
Your
Page number
Lordship,
65,
And where is the order of learned single judge? Let us see.
at annexure A, my lord. Annexure A, page number 13. ma'am. Operative portion is at page number 15.
What is it? Let us recollect.
I'll just read para number 5, my lord.
That we
It
have
brings
read,
the
it,
efforts,
consider
facts-
the representation. What is their stand? Their stand is that,
They'll give the vehicle, they undertook last date that they'll give the vehicle back and withdraw all the actions taken pursuant to the order of the learned single judge. And they themselves asked for this date, my lord, 21st, on the last date. And till now, no action has been taken.
now the vehicle has been repossessed by
They
the,
could have given that vehicle back. If vehicle is repossessed, they could have given the vehicle back.
and I would get the transfer of the vehicle. Your Lordship, there now the third party right has been created for the property. With that, I cannot transfer the vehicle to the.
They were aware about it on last date of hearing.
Your Lordship, what happened? In this case, Your Lordship, the advocate has wrote addressed a letter to the bank. I produced a document to the bank, produced before this on court, stating that the Honorable Court has directed the petitioner, petitioner to approach the DRT, and they have to approach the DRT and pursue their remedy. But whereas when the petitioner accused got the order, there was a direction to this honorable, to the bank to consider the representation. May I take Your Lordship, the page number 60, Your Lordship.
no, the vehicle was, you were already, it was demonstrated that therefore we passed the order.
He was a defaulter in the bank, Your Lordship.
Hmm.
He was a defaulter, and we have seized the vehicle. Your Lordship, may I take Your Lordship, page number 60 for 1 minute.
61,
60.
60.
This is the communication by the advocate, Your Lordship.
Hmm.
This is to inform that captioned matter was listed on 27/6/2024 before the Honorable High Court of Karnataka, Bangalore, before CH number 14. When we have appeared on behalf, the advocate for the petitioner submitted that the bank had proceeded by filing the original application before DRT, even though settlement talks were taking place. We have informed the court there was no settlement in the matter and that the petitioner is making false submission. We have also informed the court that the petitioner, after obtaining the loan, has till date paid only one installment, and that outstanding total amount is 26 lakhs. After hearing both the sides, Honorable Court disposed of the writ petition, directing the petitioner to appear and prosecute before the DRT by filing OA filed by the respondent within 3
The
weeks.
order in the earlier writ petition was 21/6/24.
Yes,
So despite that order, you seized the vehicle
Yes, ma'am.
subsequently.
Yes,
Yes,
ma'am.
yes.
List of dates may kindly be seen. List of dates may kindly be seen.
That is the point. The yes list of events.
List of dates at page number 2, ma'am.
Page number 2, 21/6/24.
21/6 order was passed.
Yes,
Then 29th, they seized my vehicle, just 3 days after.
29th. On same day, complainant.
Same date I
immediately-
went to the police station. Police said because it's a
No,
civil
no,
matter.
then there is an admission in their affidavit that they took.
There's an admission in the affidavit.
That is why we said. that.
Yes,
it's only because of the communication we have seized the vehicle,
Ah.
Lordship. Or else there was.
The Crystal Recovery Agency seized the
the admission is at page number
29.
8.
29/6. Paragraph 20. So it was seized after the interim order.
Yes, madam.
Your Lordship, because of
This
this,
is how we are.
After the disposal of the,
because of the communication, Your Lordship, I have produced at page number 60.
are they bound
By
by
the
the
advocate,
communication
Your
or the
Lordship, who has
order? madam?
appeared in the single judge, before the single judge. This seizure happened, or else definitely the bank had no intention to disobey the order passed by this court. Till Monday, Your Lordship, I speak.
You stated that the bank has decided to withdraw all the action which are in.
Yes, Your Worship. Now, with great difficulty, it was with the third party, Your Worship. The property was auctioned and it was with the third party. Now, we convinced and got the vehicle back. And now we have to redo the registration and give back the document. Just by giving back the document, it will not, property, it will not help.
Something must be there in support of your stand that you have withdrawn the action.
We have brought the vehicle, Your Worship, from the third party.
No, your decision to withdraw the things.
Your Lordship,
This is your
all that we have to do is, Your Lordship, now we have to change the RC name. Now it is in the name of the third party.
Something in black and white from the bank to show that this order is acted upon. How do we know, how anybody else will know that you acted upon by withdrawing all action?
I
Some
submit, Your
decision,
Lordship,
some
we have repossessed the vehicle, Your Lordship. Now
where is that in the process? In air, in mind?
No.
But
It is
something must be on paper.
No, it is.
You are a bank.
Bank, Your Lordship. It is in the custody of the bank. Now, now the document, RC has been transferred to the name of the auction purchaser.
But in order to implement, there must be some decision on your files, some noting, some decision, some communication.
Yes, sir.
Where is
Till Monday, Your Lordship, I think.
you give this to? Keep here.
Monday, Your
Monday. Twenty, 28, 27 you want? 28. 28.
Much.
Number 47.
Appearing for the complainant's counsel.
Lords, in this, I
Order of the
request,
learner single judge dated 3/7/2024, directed to complete the election process within 3 months. My lord. Then, while after service of notice, may kindly request lordship to see the order of your lordship dated 23/9/2020. 23rd September 2024.
My lords, in this, we have filed an application for extension of time as liberty was reserved by the learned single judge. The matter was listed today at 2:30, my lords. Learned single judge has adjourned the matter to 29th. I request it may be taken up after 29th, my lords.
May I make one request? Madam? Just look at the order of your lordship dated 23/9/2024. Where your lordship said on the next date, learned government and the additional government advocate directed specifically to state by filing an affidavit as to the steps taken by the competent authority in terms of the directions of the learner single judge, which requires holding of an electing cooperative society within 3 months. The case of the complaint is no steps are all taken holding the election unless satisfactory reply is filed. Seriously will be taken. Even reply is also not filed. Your lordship's order is also not complied with. Forget about the directions of the learner single judge.
As learned additional advocate general Ms. Pratima Honnapura submits that the who is by your for
My lords, application for extension of time, accused number 1.
by state.
Accused number 1 has filed application before the learned single judge, my lords.
My lords, it's in compliance stage, my lords. It is in compliance stage, my lord. Lordship, I kindly grant
On
2 weeks
30th,
time.
11/24, order was passed in which the statement of learned advocate respondent was recorded that the appeal is filed against the order brought under contempt. When today contempt petition comes up consideration, no progress is shown in respect of the appeal stated to have been filed. Learned advocate, paragraph for the
I'm representing my
complainant
colleague.
invited attention of the court to the further observations of the court in aforesaid order dated 20th, 11/24, that the direction was also issued to obtain appropriate orders in the appeal before 21/1/25. Failing with, the respondent shall be liable to comply with the directions.
I pray for 2 weeks time, extension of 2 weeks, my lords. Before
Learned
that, I shall
advocates prays for 2
comply
weeks
with the,
time
please,
to
comply with the office
What?
objections.
extension of 2 weeks time in relation to above. Full stop. The time is granted up to, today is what we are, 2 days, 20, time is granted up to 3rd of February, within which time all office objections will be removed and the appropriate order shall be obtained in the writ appeal stated to have been filed. Full stop, comma, failing which the, who is to comply with?
Commissioner, Bangalore Development.
Commissioner shall have to remain personally present to explain the conduct of the court, put up on 5th of.
Lord, always a writ appeal cannot be an answer for them to disobey the order is my respectful.
Since they have filed, let them have
Yes, my lord, while I understand that.
What is the
60
direction?
16 months delay in writ appeal. When contempt proceedings are taken up very seriously by the honorable court, they come with a antidote about writ appeal. When the direction is simple in terms of making the payment, excess payment collected contrary to the rulings of this honorable court while allotting a site in favor of the complainant who fought it for more than 20 years, my lord. Today, when it comes to this, they want to, they seek a challenge to the.
We impose cost.
Yes, my lord,
That's a simple, it's a appeal is filed on a limited
Because there is
ground.
a clear,
regarding-
this is in 20th 11. Today we are.
I
on-
only pray for 2 weeks time, my lords. Before that, I shall make sure that the writ appeal is complied with and it is posted before your lordships for appropriate orders. my lord.
Thereafter, the saga will be connect the writ appeal with the contempt and then they go as twins. All this, I'm only saying it, bring it
Entire
to
month
the-
of December you consumed,
I was in-
20 days of
I
January.
beg
you
your pardon, my
consumed,
lords. I'm at fault, my lords. I'm
10
aware, my
days
lord.
of November you consumed,
Lords, I'm
2
aware,
months.
I'm aware I'm at fault, my lords. Lordship may kindly grant me 2 weeks time. I shall make sure that it is complied and it is.
Not the order
No, no,
compliance,
no 2 weeks.
objections
No.
compliance, he says.
We will not act unless we are,
Lords,
Correct.
one opportunity, my lords, to.
we'll
comply
give
with-
but on cost,
My lords,
payment
my
of
humble
cost.
submission, my lords.
On
Lords.
20th 11/24, following order.
May
was
may I
passed.
make one humble
Place the
submission?
order on
May I make
20th.
one humble submission? Lordship may kindly grant me weeks time, my lords. I shall make sure that the writ appeal is complied with and posted before your lordships for appropriate orders, my lord.
On following order, on 20th 11/24, following orders was passed for the order. Today, when the contempt petition comes out, comes up for consideration, learned advocate may so and so for the respondent, PBMP
BDA, my lords.
Bangalore
BDA
Development.
has raised his hand, his helplessness to submit that there is no progress in the appeal filed, full stop. It is startling to notice that there is blatant disregard of the observation of the court by the authority.
Lords, I beg your pardon, my lords.
However, taking a lenient view, but imposing cost of rupees token cost of 1,000, the time is granted for 1 week as prayed for to ensure that the appropriate orders are obtained in appeal, failing which a stern view will be taken. The cost shall be paid to the petitioner within 1 week.
Please, my lord.
Date is given.
May I request the appeal?
Now, every adjournment, if you pray, will be with increased cost.
Please, my lord. I shall make sure that it is complied.
You do it.
Date may kindly. be-
Date is on 4th of February.
I'm
May I
obliged.
request the appeal be listed on 4th January? Before that, I shall make sure the complaint, it is
We are
complied.
not here to list your appeal.
Lords,
Are we the registered judicial?
Lords, I'm sorry.
No,
I'm
no.
requesting for connecting of the writ appeal with the.
You
contempt,
go
lords.
there and we are dealing with the contempt matter. That too, a non-compliant contempt.
Please.
Fast. Complete 5 minutes. Complete the course. Opening matters are- Office objections matters from 75. Sorry, 65 to 64. 64, second time. In 64, 4 weeks time is granted to remove the official. In 65, 3 weeks time is granted. In 66 to 66, 67, 68, 69, 70, 71.
Lordships
Time is
kindly.
time is granted. Failing which the appeal of petition concern shall be dismissed automatically without reference to or order of the court.
Lordships
All-
kindly.
Order that. That.
Tier number 67 lots.
Yeah.
Kindly, short date may be accommodated, lots. Your lot.
Serial number 60, Your Lordship. I seek the office objection be overruled, Your Lordship, because I clearly mentioned the section of Indian Criminals Act be considered, and I've even served the copy of the video to the public prosecutor, Your Lordship. 60, Your Lordship. It's been coming as the same objection from these 3 attendments, Your Lordship. Number 60, Your Lordship. And as per the IA 24 or 1 of 24, I've given the specific prayer with the particular clause of 65A and 65 of the Indian Evidence Act, Your Lordship. I've even amended the prayer in the office objection of IA 1 of 2024. Your Lordship may kindly look at the prayer also in the IA, Your Lordship.
Part in person. Petitioner part in learned. Part in person, petitioner. States that the office of justice are complied with.
Yes, Your Lordship.
The
I seek the
registry shall
overrule of
verify.
that.
The registry shall verify the said aspect. Full stop. If the office of justice complied with, the petition shall be further processed. Yes, next.
Your Lordship, serial number 62, Your Lordship. 62, Your Lordship. Your Lordship, the notice has been served and the wakalat has been filed by all the respondents. Hence, the matter may be listed
Same order.
tomorrow.
Serial number 53, my lord, may be listed on 31st, writ up in 630 has been, my lord, filed. That is listed on 31st of.
Along with the office objections, I have made some submissions. That's my kindly direct office to verify and post for admission.
Which number? Serial number? Serial number?
76.
76, same order.
Your Lordship, kindly serial number 83, madam.
'81, sir. Yeah. Please, sir. ಸರ್ ಅದರಲ್ಲಿ ರಿಕಾಲ್ ರಿಓಪನ್ ಅಷ್ಟೇ ಸರ್ ಏನಿಲ್ಲ ಅದು ಅಫಿಡವಿಟ್ಸ್ ಓವರ್ರೂಲ್ ಮಾಡ್ಬೇಕು ಸರ್ ಅಷ್ಟೇ ಅಲಾಂಗ್ ವಿತ್ ಅಡ್ವೊಕೇಟ್ ಸಬ್ಮಿಷನ್ಸ್ ಏನಿದೆ ಸರ್ ಅದು ಇಲ್ಲ ಸರ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನಿಲ್ಲ ನಾನು ರಿಕಾಲ್ ರಿಓಪನ್ ಅಪ್ಲಿಕೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೆ ಅಲ್ಲಿ ಹೌದು ಪ್ಲೀಸ್ ಸರ್ ರೈಟ್ ಸರ್ ರೈಟ್ ಸರ್
71.
55 next month ಅಂತ ನೋಡು 55 next month ಕಂಟೆಂಪ್ಟ್ ನಾಳೆ
serial number 50. 55 ಅಲ್ರಿ 50 ಸರ್
ಇನ್ನೊಂದು
83 ಒಂದು
ಸರ್
55 ಅಂತ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಾನು
71, 7 time, 8 time, ಬಂದಿದೆ 71.
62
71 point.
serial number 50
ನಾನು ತಪ್ಪಿದ ಬಂದಿದ್ದಾವೆ ಸ್ಟೂಡೆಂಟ್ಸ್ ಎಲ್ಲಿ ಬಂದಿದ್ದಾವೆ ಹಾ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಡೇಟ್ ಕೊಟ್ರಾ
ನಾ ತಗೊಂಡಿಲ್ಲ
But